Criminal appeal is dismissed.
Prepared a date before your lordship takes up this matter. I may pardon my lord. Before your lordship takes up, I have one request that your lordship had directed me to file a written note.
You give it.
I am ready. It is ready. I'll file it tomorrow.
Today. No, today you file it, sir.
Today, my lord, after lunch, my lord. It
All
is
right,
ready
today
only
after
for
lunch.
correction.
All right, but file it after lunch.
Okay. Here, my lord, I prepare a date chart, my lord.
My lords, the last order was on maintainability. You had questioned the petitioner.
Correct.
I just have a judgment which I would like to place with
Hmm.
you.
That was probably my friend was not there. That has been that judgment your lordship given that para 56 says it is the para 50 227 that question raised that day. That judgment I have cited that the Supreme Court said it is the dependent on the judgment the single judge has which power the single judge has exercised. Your lordship, I have shown that in this case was
Para 9.
this case
In para 9, he says it's 226.
226.
Which judgment are you referring to?
My lords, this judgment is a recent one of the Andhra Pradesh High Court. It essentially discusses the law on whether a writ appeal is maintainable arising from a labor court, and a tribunal is similarly placed as a labor court under the Act. So it discusses all the Supreme Court judgments right from Surya Dev Rai to the 2019 judgment, my lords.
All right. Pradesh.
My lord, may I finish?
Justice Khanwilkar's judgment is, I think, that Ramkishan Fauji. That, I think, is Justice Khanwilkar's judgment.
Yes, my lord. It's at para 16 of this.
Correct.
So para 17 discusses the conclusion of this judgment, my lord. It says
Right.
labor court exercises its power under 227.
Correct. Yes. You address this also.
Malad?
You address this also, I said.
Yes, the last occasion I had that judgment your lordship has given me. That also says the same thing. And only writer that what is the power which has been exercised by the single judge has to be seen. In this case, your lordship has seen
But
that.
even if the single judge says 226, suppose it is in fact 227, then what happens? Single judge may say anything.
My lord.
Ah.
But that judgment, my lord, says, my lord, that if it is dependent on the judgment rendered by the single judge and the power exercised by him,
No, but the
that will
nature of that
depend on
function,
whether
no, nature of the function won't change because the single judge said it. I'm doing it under 226.
that part, my lord, I have not. In fact, that I thought that is gone that day. I have not prepared on that, my lord. May I argue on merit, my lord?
No. In fact, last hearing, we noted this point.
Yes, your lordship noted that point. Your lordship also gave me that judgment. In that judgment, paragraph 56 says that the maintenance of the writ appeal will dependent upon the jurisdiction exercised by the single judge. If the single judge has exercised 226 jurisdiction, then it will be writ appeal will be maintainable. And if it's not, then no 227.
The only added thing now is, what if the single judge wrongly says it's 226 when in fact
that part, my lord, I have to examine. Then
no, there's no examine. You just to submit. That's all. The judgments are the same.
That judgment is said that it is dependent on the
last of the judgments of the Supreme Court is this Ramkishan Fauji versus State of Haryana. It is 2017 5 SEC 533.
My lords, the judgment which you refer to in the last order is LIC versus Nandini J. Shah. It's a 2018 judgment. It was regarding the Public Premises Act. Whether the officer there is, the appellate authority there is a civil court or is it under 226. So that is not referred to in this judgment.
So what happens then?
But there the court said that the relevant authority is not a persona designata because it exercises powers under the Civil Procedure Code. It has an established system of appeal which exists. There are a set of judges who have been exercising that
it
power.
was held to be maintainable.
No.
No.
It said that intra-court appeal is not maintainable because
in Nandini Shah.
Nandini Shah, yes.
In fact, you had argued that it's notwithstanding Nandini Shah, it is maintainable.
Yes, Nandini Shah in para 56 it said, madam.
What?
That if it will be dependent upon the jurisdiction exercised by the single judge.
You have Nandini Shah. Let's see the Nandini Shah. None of you has a copy of that. I have it.
Citation.
This is also correct.
Paragraph 52, my lord.
No. How does it begin? Because we have the SEC here with us.
That is, it starts from similar view expressed in Joginder Singh Ji Supra. In this decision, it has been held that the order passed by the civil court is amenable to the scrutiny only in exercise of jurisdiction to Article 2 of the Constitution of India, and no intra-court appeal is maintainable from the decision of a single judge. In paragraph 30 of the reported decision, the court observed thus: from the aforesaid pronouncement, it is graphically clear that a maintenance of a letter pattern appeal would depend upon the pleadings in the writ petition, nature of character of the order passed by the single judge, a type of direction issued regarding being had to be jurisdictional perspective in the constitutional concept. Bearing the civil court from the order as held there, the 3 judges bench in the Radheshyam Supra, the writ petition can only lie under 2 transition of the constitutional order from the tribunal, cannot always be regarded for all purposes to be under Article 2 transition of the Constitution. Whether the learned single judge has exercised jurisdiction under 226 or 2 transition or both, needless to emphasize, would depend upon the various aspects that have been emphasized in the aforesaid authorities in this court. There can be order passed by the learned single judge, which can be construed as an order under both article in composite manner. For they can coexist, coincide, and imbricate. We reiterate that it would depend upon the nature, contour, and character of the order, and it will be the obligation of the division bench to hearing the letter patent appeal to dissent and decide whether the order has been passed by the learned single judge in exercise of jurisdiction under Article 226.
Yes.
Decide whether the order has been passed by the learned single judge in exercise of jurisdiction under Article 226 or 227 of Constitution, or both. The division would be required to scrutinize whether the facts of the case justify the assertion made in the petition to invoke the jurisdiction under both articles, and rely prayer on that foundation. Be it stated, one of the conclusions recorded by the High Court in the impugned judgment pertains to demand of and payment of the court fee. We do not intend such that. This is so, Mala, this is dependent upon the jurisdiction exercise upon by the learned single judge, Mala.
No, not merely does not. It does not say that if the single judge says it's 226, it does impact 226. Single judge may say anything.
There cannot be a single straitjacket formula for same. Needless to the High Court, while exercising the jurisdiction under Article 2% of Constitution, has to guided by the laid down by this court and some other judgments that has been referred to in Radheshyam. In paragraph 42.5, the same judgment, the court authority concluded that by order passed by the civil court in amenable to scrutiny of the High Court only in exercise of under jurisdiction under Article 227 of the Constitution, in which is different from Article 226 of the Constitution as per the
My lords, as to the question of nomenclature, the judgment.
Do you have an answer to the question I just now asked?
I couldn't say, my lord.
Which of these decisions
Right.
arises of the Supreme? Which of these Supreme Court decisions arises from an award of a labor court? There's a full bench of our High Court. There is a full bench of our High Court. Do you have that?
no, my lord.
There is a full bench of the Delhi High Court.
Sir, there is a. When I ask you a question, you answer something else. I don't know why you do this.
Apologies.
I'm asking you, is there a decision of a full bench of our High Court?
I'll have to look, my lord. I'll get
There is. I have myself been shown such a decision. A full bench of our High Court. Is any lawyer in this room aware of the full bench of our High Court on intra-court appeal? Not a single lawyer? We have also quoted that full bench in our order. And this is government.
My lords, if you may kindly pass it over, I'll get you the judgment in by the end of the board.
insofar as our High Court is concerned, that came from a criminal matter on 226 to 27 by Justice Waghela, 3-judge bench.
There is a full bench in a civil matter, sir. It's a full bench decision, bench of 3 judges. Of
Yes,
this court.
3 judges also, but from a criminal
No,
matter
no,
in
that is separate.
226
That is
by
a separate
Justice
thing, sir.
Waghela, while sitting with 2 other
As a criminal
judges.
matter,
my
we double
lord.
have one. It is a criminal matter, we double have one. Supreme Court of the Supreme Court we vote, I think that's about it.
Mr. Mishra, I thought you'll be aware of it. That intra-court appeal, Your Lordship. Full bench judgment, Your Lordship, I'm sorry. Mr. D.K. Manthi is not here.
No. No, he's not.
See, parties on, concept of the parties on both sides seek time to present case law on the question of maintainability of the present list on. You have to do proper research, sir. Not
Well,
enough.
I thought, my lord, last occasion that part is gone.
Not over. In fact, very much we put it down so that you will address it. March 22nd. Or just look at this one more judgment.
My
You
lord.
can note it down.
My lord.
Caparo Engineering India Limited versus Umed Singh Lodi. Caparo Engineering India Limited. This is super judgment. Where is it?
No, sir, the criminal. The criminal.
So you have to go to para 5.8 of that judgment.
The criminal.
And 7.9. Actually, para 7.9. Para 7.9 of that Caparo judgment. You don't know how this is been. This is 20. This is a 2021 judgment.
21 judgment.
2021 judgment. Just keep this with the paper.
Supplementary list old matter item number 2. In this case,
Yes.
the Honorable Single Judge in her challenge, and let the limited grievance is enhancing the quantum of compensation towards damage from 2.5 lakhs into 8 lakhs with 8% interest. Well, the crux of the case is Exhibit 9. And all the courts are depending on that exhibit while quantifying the damage towards the erection of electrical poles and the substations erected therein, my lord. My lord, I will not take so much of time of your lordship.
No, 1 minute.
My lord.
This was a decree of a civil court.
Pardon?
Decree of civil court.
No, it is not a decree of civil court. Says that I have no jurisdiction. You go and approach the district judge under the Telegraph Act. Then the present respondents prefer an FAO. In FAO, the law and court says yes, the civil court has jurisdiction and remitted the matter back. We have challenged that before the High Court in writ application.
Why?
Because we say that the judgment is illegal in view of the fact under the Telegraph Act. There is no jurisdiction, and under section 10 of the electrical, it is only the district judge to quantify the damage caused. Therefore, this court remitted the matter back to the district judge.
That's so. So you're not challenging on merits, only on maintainability.
No. I am only confined myself on the question of quantum, nothing else.
No. So you're not questioning on maintainability.
No, my lord. Though I have taken that point, now I'm not pressing that.
Now you're not pressing maintainability.
Otherwise, it should be calculated by the collector first.
If you're questioning only on quantum, so it is a civil court's order which you challenge in a...
Yes, by them, my lord. By the respondents.
Sir, you are the one now in writ appeal.
Yes, my lord.
The matter arose before the single judge or the behest of the respondent asking for enhancement.
Yes.
So from that, how is the writ appeal maintainable? Same problem.
No, he has not come in for enhancement. We have prepared that.
You have no. He has
yes.
Got enhancement, sir.
Yes, my lord.
You are challenging the enhancement.
If your lordship will go 2 paragraphs of the judgment of the additional district judge.
How is it maintainable? Is the question I'm asking you now. This writ appeal, how is it maintainable?
Because it is under the Telegraph Act.
How is a writ appeal maintainable, sir? Writ appeal, order of intra-court appeal, how is it maintainable?
My lord, my submission.
The writ petition was arising from a decree of a district judge.
Yes.
How is a writ appeal maintainable?
Because to that my submission for lordship is this is not under a suit but under the Telegraph Act.
Doesn't make a difference, sir. Anyway, he's examined the
under the
evidence.
He
has anyway examined the evidence.
Pardon?
He has examined the evidence.
Yes.
And came to a conclusion.
Yes, my lord.
Decision has been rendered.
That is my point, my lord. If your lordship will go to the order passed by the learned additional district judge, your lordship will find the honorable single judge as well as the additional district judge are confining with one exhibit 9. After thorough analysis of exhibit 9, the award was passed 2.5. And there is no other material before the learned. Well, except exhibit 9, there is no other material before the honorable single judge to come to a conclusion for enhancement of the compensation. This is my... If your lordship permit me, I will place only 2 paragraphs.
So the answer to the full bench judgment, Mr. Nanda, this is a full bench of Justice B.S. Chauhan, Justice L. Mahapatra, and Justice A.S. Naidu. It's in an LPA number 7 of 2008. It's not a criminal matter. So the full bench citation is 2008, 2 OLR, full bench 725. Separate. Yeah, that's separate. Another judgment, sir. This judgment has nothing to do with criminal matter. That's right.
The other judgment I was citing was
that is an earlier judgment.
A criminal matter.
Correct. Yep, correct. No, LPA. Correct. Very clear, sir. Part 46.
Yes, my lord.
Of this full bench decision. Are you aware what I'm talking about?
Yes, my lord.
What am I talking about?
Whether this writ appeal is maintainable if it
But now when I told you para 46, what was I talking about?
Para 46.
Of what?
But I have not.
Ah. Just give it to. Just give this to. Will you thank us, sir, for doing the research, or we will not?
But,
He's hesitating. He's still thinking whether he should thank us or not.
My lord, any knowledge is always welcome.
No. See,
So
this is
we'll
all
always
already
multiply by
stored
that.
knowledge thanks to Justice Raman. He's so resourceful. So whether you people thank or not, I'm thanking him. So kindly read para 46 of that judgment, sir.
well, in view of the authority's pronouncement of the Supreme Court, we are of the view that after introduction of section 100A with effect from 1/7/2002, no letters patent appeal shall lie against the judgment order passed by the Lord and single judge in an appeal arising out of proceeding under the special act. Yes, ma'am.
You may see first paragraph also.
Yes.
You may see first paragraph. From where this cropped up.
It is an order in an FAO. Just see the first paragraph, sir.
Yes, my lord.
It's an order in an FAO. Your case is also an order in an FAO. Your case also arises from a special act.
Yes.
Ah. All right. You say the present appeal arises from an order of a learned single judge in CMP number 1006 of 2014, which in turn was a challenge to an order passed by the Additional District Judge Bhubaneswar in FAO number 74 of 2000. Paragraph. In view of the decision of the full bench of this court in Muhammad Saud versus Dr. Major Sheikh Mahfouz, 2008 2 LR bracket FB 725, the present appeal, writ appeal, is not maintainable as an intra-court appeal. Stop. Consequently, leaving it to the appellant to seek appropriate remedies in accordance with law, this writ appeal is dismissed on the ground of maintenance.
I am for the opposite party now.
The amount deposited in this court, together with any interest thereon, be released forthwith to the respondent upon proper action. How many respondents are here?
Lord, five respondents. One prayer may be allowed.
No. Can't be critical, sir. 1 to 4 respondents. 1 to 4.
Yes, 1 to 4. You may kindly see.
Upon proper identification.
No, respondent number 1 has in the meantime expired. I have filed an application for substituting the LRs.
Or
that is pending.
That application first you allow.
IA number 3865 of 2022.
This 3865 for the reason stated, the application is allowed. The substitution is prayed for is allowed. And then in that main writ appeal, you say the amount deposited in the court together with interest thereon be released by the registry to the parties 1 to 4. Upon proper identification. So for this limited purpose, the matter will be placed before Registrar Judicial on 2nd January 2020. Before the Registrar will say, right? Before the Registrar on 2nd January 2023. Yeah, writ appeal is dismissed on the ground of maintenance. All right.
Supplementary list item number 3.
The last order, my lords, I had to get the records. My lords, the records haven't come. My lords may give me one last opportunity. This is with regard to, my lords, an Anganwadi worker appointment. So there was an inquiry conducted by the revenue inspector. I called for the records, my lords. My lords may call it first week of reopening. I'll get the records.
Counsel for the state needs more time to produce the record of the ADM Puri. That is request list on 29th March.
Well, just one submission, and it's with regard to the maintainability aspect. With regard to the maintainability aspect, supplementing Justice Raman's. So the matter actually traveled to the Supreme Court. The Supreme Court, in a two-judge bench, division bench, upheld the view of the.
Show us a judgment.
Yes, ma'am. It's 2010-13 SCC 517. Mohammed Saud versus Dr. Sheikh Mahfouz.
As affirmed in that order, as affirmed by the Supreme Court in
Mohammed
Saud versus
Mohammed Saud and another versus Dr. Sheikh Mahfouz and others. This particular matter traveled to 2010-13 SCC 517.
Okay, thank you. That's good. Not big. All right. Yes.
Supplementary item number 4.
Lordship, I am present on behalf of SV Ponda, Subha Vikas Ponda.
No, 1 minute. Who's for the appellant, sir? Who's for the appellant? Sir, are you for the appellant?
My lord. On behalf of Mr. KK Swain, no instruction. And item number 5 also no instruction.
Counsel for the appellant states that he has no instructions. Dismissed. Both 4 and 5.
Item number 6.
My lord.
Item number 6.
None appears dismissed.
Item number 7.
Your Lordship may see the last order. The Lordship said, asked me to bring that notification on record. In fact, as my learned friend says that the sworn affidavit has already been sent by SEL, but unfortunately that was sent on 9/12, but it has not reached him. So if your Lordships can give me 2 days time, I can file it and can be taken up next week.
More time is needed to place the affidavit on record in terms of the order dated 20th October 2022. List on 14th March. All right.
Can it be a little shorter? Deeply applied.
Item number 8.
Item 8, my lords. I am appearing in the second case on behalf of Mr. Das. The copy may be served on me.
First, who is for the appellants?
I am for the appellant, your lordship. Even Mr. Das has intimated me that he doesn't have a copy and he's appearing today. So if your lordship permit, I'll serve him a copy.
No, what is the matter about, sir?
Yes, your lordship. In this matter, I'm challenging the order dated 19th of March 2019, your lordship. Now, against the very same order, even Berhampur University has filed 2 appeals, your lordship. That is WA number 179 of 2019 and WA number 180 of 2019, your lordship. Now, what has happened in the meantime, those 2 appeals that have been dismissed for default. Now, against that order, they have filed an application for restoration of the same, your lordship.
Tell us what this matter is about, sir. All that can wait. Tell us.
Yes, your lordship. The only difficulty is because the university is appearing in this case also. Even they have a stand to adjudicate, your lordship.
No, what is your case?
Yes, your lordship. There was an advertisement, your lordship, in 2015. I shall kindly see the advertisement. That is at WPC number 416, your lordship. I have not included the writ appeal. I shall kindly refer to the writ petition, your lordship.
Which 848?
Yes, your lordship. 4008, your lordship.
4008?
Yes, your lordship. Writ petition number.
Okay. What is the other writ petition about? Why are the 2 writ appeals?
Yes, your lordship. Because by the common order, the both are disposed of. So I have to file 2 independent writ appeals.
What was the other writ petition about?
Yes, your lordship. I will say that, your lordship. In the first application, the petitioner has come forward challenging that my application, which was rejected, is dehouse the rule. That is the first writ application. The second application, they have come forward and saying that I have secured better marks than the present appellant. That's why the rejection of his candidature should not be done. And it is.
So basically, you applied for lecturer in Odia.
Yes, your lordship.
So what was it? You were rejected on what ground?
I was not rejected. I was appointed, your lordship. I was appointed. These 2 petitioners, they come forward. One is saying that my application was rejected and the threshold is illegal. The other is saying I was at serial number 1. Why my application has been rejected?
Not the application was rejected. My recommendation for appointment was rejected by the syndicate, changing the rules after selection.
That is the case, Your Lordship. Now I will.
So the learned single judge said that you cannot change the rules
after the game has begun.
My lord.
All right.
But my humble that is not the case, Your Lordship. Why I'm saying so? I will go first by one, Your Lordship. The first one is for the why the rejection, the application was rejected, Your Lordship. Now, in the advertisement, why I'm saying so advertisement, Your Lordship, I kindly say other advertisement. That is the page number 21.
Yes, of the writ petition.
Yes, Your Lordship. There was one post for Odia lecturer. That is for your category, Your Lordship.
Correct.
Now, for the post of lecturer, what was the qualification and experience prescribed, Your Lordship?
Right.
At page 25, Your Lordship. For the lecturer, the petitioner in that case is relying upon serial number 3, Your Lordship, the non-affirmative clause. Notwithstanding anything contained in subclauses 1 and 2 above, candidates who are or have been awarded in a PhD degree in accordance with the University Grants Commission minimum standards and procedure for award of PhD degree regulation 2009 shall be exempted from the requirement of the minimum eligibility condition of NET/SLET/SET for recruitment and appointment of assistant professor or equivalent positions in the universities. Now, on basing on this clause itself, the petitioner in WPC number 848 has come forward that because I have secured.
Second.
नहीं मैं पार्ट बाय पार्ट जाऊँ
नहीं 8 4008
ताऊ पे नहीं सिर्फ सेकंड में जाऊँ
Tell us again. What did you secure and what was the position? You had a PhD.
I also have a PhD, my lordship. I also had the NET. But my lordship, the first application, that is, they have not challenged my appointment. He has only challenged as to why my application has been rejected. I should kindly appreciate the fact that his petition, because he has filed, challenging the rejection of his application on the ground that I had the PhD qualification, therefore I am exempted from the required NET qualification, Your Lordship. Now, on the basis of what the university has rejected, Your Lordship, is he has secured the PhD certificate in 2003, Your Lordship. It is prior to that this 2019 guideline regulation, Your Lordship. The 2009 regulations specifically stipulates the way of condition, Your Lordship, the PhD degree has to be granted. That was not in accordance to 2009. What the Honorable Single Judge did, I'll show it to Your Lordship. It's at page number 46, Your Lordship, of writ appeal number 209. Page number 46.
Yes.
The UGC minimum qualifications required for the appointment and career advancement of teachers in universities and institutions affiliated to it. Third Amendment, Regulation 2009. The provisions mentioned in the said regulation has been substituted by following paragraphs. The NET shall remain the minimum eligibility condition for recruitment and appointment of lecturers in universities, colleges, and institutions. The advertisement, Your Lordship. The persons who have secured the PhD certificate, they're exempted. That has to be secured in terms of the 2009 regulations, Your Lordship. Now, at paragraph 9, keeping the above regulated provisions in view, this court proceeded to adjudicate the case of Dr. Ashok Kumar Panda, the petitioner in WPC number 848/2016. The admitted fact is that he does not possess the NET, SLET, SET qualification, but he had acquired PhD degree by the time the advertisement was issued. He has submitted his application for the post of lecturer in Odia under unreserved category. Needless to say that all the universities, including Bharpur University, are adopting the exemption from requirement of minimum eligibility condition of finding NET, SLET, SET for recruitment and appointment of lecturer in case of the candidates who have been awarded PhD degree as per the UGC minimum qualification 2009 guidelines. Acquisition of the PhD degree by petitioner is not disputed, but he has not qualified NET, SLET, SET. That by itself cannot disentitle the petitioner from participating in process of selection to the post of lecturer in Odia under unreserved category pursuant to advertisement issued by the opposite party university in view of the Resolution 2009, full stop. Further, this is important, Your Lordship. Further, as per the general instruction dated 6/2004, issued by OP number 2, under subclause 1 of subclause clause 4, it has been stated that NET shall remain compulsory requirement for appointment as a lecturer, even for candidates having PhD degree. But the candidates, the next page, Your Lordship, who have completed MPhil degree by 31/12/1993 or have submitted PhD thesis to the university in the concerned subject on or before 31/12/2002 are exempted from appearing the NET examination. Admittedly, the petitioner has submitted his PhD thesis prior to 31/12/2002, that is on 27/2002, and by the process he is exempted from appearing the NET examination. And basing upon such criteria, he was also called upon to appear in the interview pursuant to advertisement, but issued on so and so by Devonshire University, and that issued by 2011. In view of the exemption being granted under Resolution 2009.
What is wrong with this finding?
My Lordship?
What is wrong with this
Yes,
finding?
Your Lordship. The Honourable Single Judge has relied upon the general instruction that was issued by the Chancellor of the City for Your Lordship. Now, in the meantime, a regulation has come into force, Your Lordship. It's the settled principle of law that when a regulation is there, it will always override the general instruction, Your Lordship. So kindly appreciate the fact that in the advertisement itself, it was clear that the Regulation 2009 has to be taken into consideration while giving an exemption.
So he did not admittedly have a PhD degree, he had only submitted a thesis.
No, yes, he has a PhD degree, Your Lordship, but that has not been given in accordance with 2009 regulation, Your Lordship.
Meaning?
My Lordship, in 2009, I don't have the regulation, that's why I was taking time for Your Lordship. In 2009 guidelines, there was a criteria as to how, on what basis the UGC affiliated university has to give a PhD certificate, Your Lordship, PhD degree. He doesn't have that. On that basis alone, his application was rejected, Your Lordship. My case is, Your Lordship, he possesses PhD degree. There's no
then the circular is of no meaning. So you keep the circular aside, because the circular is only to say even those who have submitted a thesis by 31st December 2002 will be eligible to be considered. That's the limited purpose of that circular.
It was not a circular, Your Lordship. That's a general instruction.
Sir, whether you call it instruction or a chit of paper, the purpose of that was to only permit those who had not yet got a PhD degree,
yes, Your Lordship,
but who had only submitted a thesis to also be considered.
Yes, Your Lordship.
But since you say in his case he already has a PhD degree, that circular or instruction or even a chit of paper is not relevant.
Yes, Your Lordship.
So no, after you keep that aside, on what basis do you attack his his eligibility?
My Lordship, again, I'm reiterating, the PhD which he possesses, it is not in accordance with the UGC guidelines, Your Lordship.
Meaning what? I don't understand. What is the meaning of that? Not in accordance means what?
In 2009, my Lordship, UGC has framed certain guidelines on what basis the PhD certificate has to be granted. Prior to that, 1990 guideline was there. Our submission is, Your Lordship, the PhD degree which he possesses, is it not in terms of the UGC guidelines itself?
How? I'm asking you how, sir? You're simply making a broad statement. It is not in compliance with.
Yes, Your Lordship.
Which provision and how?
If Your Lord, I don't have the regulation here, so that's why I'm asking.
No, I'm sure it is discussed in the writ petition or somewhere you must have raised it.
No, it's not there, Your Lordship. That's why I'm saying if Your Lordship will keep it tomorrow itself.
There, how do we allow you to raise it for the first time here in writ appeal?
It's there, Your Lordship. It's there.
Where is your content on that?
In the writ appeal, there's a pleading, Your Lordship, I have raised in the writ appeal.
No, in writ petition.
My Lord, writ petition, they have not filed any counter. My Lord. He has not filed any counter.
Then how are you challenging his qualification?
And the university challenge of the university has already been dismissed. And the Honorable Single Judge has also dealt with that aspect, the regulation. My Lord, here only. The particularly, he was reading out.
Which page?
My Lord, page 49, my Lord. Particularly when the candidature of the petitioner pursuant to the advertisement issued by the very same university in 2011 has been granted exemption under Section 9, my Lord. And the general instruction issued by the university in Annexure 8 series dated 6/5/2004. Therefore, the action of the authorities excluding the name of the petitioner from the eligibility list of the candidate cannot sustain, my Lord.
What has happened after this judgment of the single judge?
My lord, because my lord, writ appeal was filed and stay was obtained, my lord, we could not be appointed, my lord. My lord, the respondent number 4, who has been selected by the select committee, he could not be appointed, my lord.
And the companion writ appeal is about some other candidate.
My lord.
He was also selected.
No, he was selected, but in the waiting list.
Oh.
I was the first.
So you.
And he was the specific finding of the single judge.
Your Vibhuti Bhushan Acharya.
My lord. And his guide was one of the member in the interview.
So he did not even file a reply in the writ petition?
No, my lord.
My lordship, what has happened? Let me clarify on that aspect. I have appeared. I have not appeared. Some other counsel has appeared on behalf of the appellant in the writ petition. But as his name was not reflected in the cause list, on the date of hearing, he was not present. My lordship, kindly, the order itself reflected that on that date he didn't appear. Without hearing our side, the order has been passed.
If you choose not to appear, how can you say without hearing? Yeah. And he's chosen not to appear also. If you choose not to appear, you can't say the single judge erred in not hearing you.
That, my lordship, I cannot say.
If despite service of notice you don't appear,
I have appeared. The counsel has appeared. He has filed his
so that's different. That's not a ground for setting aside. So you cannot now be heard to say that he is not qualified.
My lordship, kindly give me 1 day time. I can produce the records to your lordship because the university is not appearing.
You did file a counter before the single judge. Why should we permit you now?
At least I will rely on the counter of the university, your lordship. That much I can do. Because I don't have the copy of the counter affidavit. At least I can rely upon the counter of the university, your lordship.
No. Is anyone appearing for the university? Who's appearing for the university?
Yes, my lord, I am appearing for the university, my lord. The university has filed 2 writ appeals, my lord. But unfortunately, due to the untimely death of the counsel, my lord, he could not take any step. So the writ appeals and
you tell us what your stand is, sir.
Yes. When my lord, I supported my lord, now I will take my lord's at present position, my lord, after the amendment has been made, my lord, to say section 21 of the University Act, my lord, and now the appointment and service condition has been empowered to the OPSC, my lord.
So nothing remains as far as you're concerned. So why are you affected by the impugned judgment?
My lord, kindly see the notification, my lord, the amendment to the act.
All right. No. How are you prejudiced by the impugned judgment?
Now, after dismissal of the appeal, my lord, I have nothing to say.
Not appeal.
Writ petition.
Here in this writ appeal, suppose we allow this writ appeal or we dismiss this writ appeal, do you have anything to say?
No, my lord, nothing.
Nothing to say. So we just record that you have nothing to say.
No, that is not the case.
No, I'm just asking seriously.
No, my lord, I challenge that honorable single judge order, my lord, so far as the dismiss has appeal, both the appeal has been dismissed, my lord. So
in this appeal, what against the same judgment, what is your stand?
My stand, my lord, the honorable single judge has said, my lord, that one man is in the committee who is the PhD guide of the appellant, my lord. That is the ground, but we say that man, he was present in the committee, but he has not signed the proceeding, my lord.
No, but the presence in the committee itself, yes, he is not recused, then that's a problem.
Yes, that is the case.
So that is the ground on which his candidature has been set aside.
Yes, my lord. That's the ground, man.
Then that is indefensible, sir. That's the end of the matter. You're not telling us that.
I'll show you what is, if the first writ appeal goes, then automatically second appeal also goes, your lordship. I have to first defend the first appeal. That's why I'm saying that because your lordship, the university has come forward and they've conceded.
Yeah, correct.
It was not considered because of his problem.
Correct. Yeah. It's an indefensible position. All right, we discuss both.
If your lordship can give me only 1 day time, I'm not asking for it. Because at least I can go to the pleading.
What can you do about the fact that your guide sat on the committee? You can't do anything about that.
My lordship, fact. That's a blatant statement only. There is no.
No. That's a fact, sir.
University
is not even denied it.
in the counter.
My lordship,
entire thing goes, sir, then.
the selection committee, he can only recommend my name. And even though they're not recommending my name, the syndicate is the one who appoints a lordship.
If he did not disclose his interest, if he did not recuse, that's the end of the matter. He should have recused. You see, the challenge in both these writ appeals is to the common judgment dated 19th March 2019, passed by the single judge, posing of two writ petitions. That is, writ petition civil 848 of 2016, filed by Dr. Ashok Kumar Panda, bracket respond before, in writ appeal 202 of 2019, and writ petition civil
400.
Yeah.
2016.
1 minute, sir. 1 minute. Just be patient, sir. 4008 of 2016, filed by Dr. Bibhuti Acharya, bracket respond before, in writ appeal number 209 of 2019. Paragraph. By the impugned judgment, the single judge has set aside the present appointment of the present appellant as lecturer in Odia in the Berhampur University, pursuant to an advertisement issued on 24th. Advertisement issued under a notification dated 24th. Is it 22nd April?
22nd of April, Your Lordship.
22nd April 2015. Paragraph. The learned single judge has in the impugned judgment come to the conclusion that as far as Dr. Bibhuti Bhushan Acharya is concerned, no, you say as far as Ashok Panda is concerned, Ashok Kumar Panda is concerned, although he did not possess the NET qualification, he had come out in terms of the amended UGC minimum qualification required for appointment and career advancement of teachers in universities and institutions affiliated to it, bracket, regulations 2009, possessed a PhD degree. And therefore, his not having an NET could not have disqualified him from participating in the process of selection. And that the exclusion of his name from the list of 44.
List of 146.
67.
No. Exclusion from the list of 44 eligible candidates.
Right.
That is your case, sir. Exclusion from the list of 44 eligible candidates was illegal, was unsustainable in law. Full stop. Paragraph. As far as Dr. Bibhuti Bhushan Acharya is concerned, the finding of the London judge was that although the selection committee had recommended his case for appointment as lecturer under the unreserved bracket UR bracket category, the syndicate of the university appointed the present appellant It was held by the learned single judge that if the syndicate was going to differ from the recommendation made by the committee, then the matter ought to have been referred to the chancellor of the university. Full stop. Further, although no minimum qualifying mark for the viva voce test had been fixed, the syndicate appears to have passed a resolution on 27 June 2011 prescribing such minimum qualifying marks in the viva voce. This prescription of a minimum qualifying mark was after the selection process and particularly without communicating the above criteria to the candidates. Full stop. The second ground on which the candidature of the present appellant was held to have acquired, held to be, no, on the second ground on which the present appellant was held disqualified for being appointed was that the guide of the appellant, PhD guide, candidature of the appellant. Full stop. It appeared that Dr. Patnaik did not dissociate himself from the committee, although he did not sign the proceedings. Full stop. For all the above reasons, the selection of the present appellant as lecturer was held to be unsustainable in law. As consequential directions, the learned single judge remitted the matter to the university to prepare a fresh list of eligible candidates pursuant to the aforementioned advertisement, including the name of Dr. Ashok Kumar Panda. Thereafter, a fresh selection was to be conducted by a selection committee to be constituted by the syndicate. And from out of the eligible candidates, a fresh merit list had to be prepared and placed before the syndicate for its approval. The selection process was to be confined to the list of eligible candidates prepared and published by the authorities on 9th January 2016, including the name of Dr. Ashok Kumar Panda. Paragraph. In the present appeals, an order passed by this court on 24 July 2019, while directing notice to issue. Paragraph. This court has heard the submissions of Mr. J. Biswal, learned counsel, the appellant in both appeals. Mr. Raut, learned counsel for respondent number 4 in writ appeal number 209 of 2019. Anyone appearing for that other candidate?
I am appearing. OP number 6, my lords.
The
second case.
So it's appearing for Dr. Ashok Kumar Panda, bracket respond number 6 in writ appeal 202 of 2019. And
1 and 2. Respondent 1 and 2.
In both the cases.
And put the name, learned counsel appearing for the Berhampur University. Paragraph, at the outset, it was mentioned that the university itself had filed 2 appeals, being writ appeal numbers
179 and 180.
179 and 180 of 2019, which, however, have been dismissed for non-prosecution by this court on
5/9/19.
5th of September 2019.
5th of September 2019. Paragraph. Counsel of the university at the outset stated that during the pendency of the present writ appeals, an amendment had been made to the
section
just asking to
21 of the
correct
Act.
it. Right. An amendment had been made to the Orissa Universities Act 1989 by a notification dated 9th November 2020, in terms of which the entire process of appointment of academic appointment of persons in various academic positions was now taken over by the Odisha Public Service Commission. Full stop. He accordingly submitted that as far as the present appeals is concerned, the university does not take any particular position any longer. Full stop. He did not dispute the fact that the PhD guide of the present appellant was part of the selection committee, which recommended his name to the syndicate for appointment as lecturer in Odia. Paragraph. Mr. Biswal submitted that as far as Dr. Acharya was concerned, the PhD degree possessed by him was not in conformity with the UGC regulations of 2009, and therefore he would still not be qualified for appointment as lecturer in Odia in terms of the advertisement dated 22nd April 2015, which clearly spoke of the applicability of the UGC regulations 2009. Paragraph. As far as the above submission is concerned, it is pointed out by Mr. Raut, learned counsel appearing for Dr. Acharya, that the present appellant, although arrayed as an opposite party in the writ petition civil 4008 of 2016, and having been represented by counsel, chose not to file any counter affidavit before the learned single judge to question the candidature of Dr. Acharya. So he accordingly submitted that the appellant should not be permitted to advance the above submission before the court, this court, for the first time. Paragraph. The difficulty as far as the above submission is concerned is, it is one thing to say why Dr. Acharya is not qualified to be appointed as a lecturer in Odia, but entirely a different thing for the appellant to explain why he should be considered qualified to be so appointed, notwithstanding the clear finding by the learned single judge of his being disqualified for such appointment on account of the participation of his own PhD guide in the selection committee, which made the recommendation of his name for appointment to the syndicate. Full stop. In other words, the appellant is in no position to deny the fact of his PhD guide not recusing from the selection committee which considered his candidature. So the mere fact that the PhD guide may not have signed the proceedings of the selection committee will not remove the taint of bias vitiating the entire selection process in which recommendation was made by the selection committee of the appellant for appointment to the post. Paragraph. Further, the court finds that once Dr. Acharya was shown to possess a PhD degree, and without there being any material before the learned single judge show that he had not validly acquired such PhD degree, the conclusion that he was wrongly excluded from the list of eligible candidates cannot be faulted. Paragraph. As far as Dr. Ashok Panda is concerned, the court is unable to find any error having been committed by the learned single judge in requiring the inclusion of his name in the list of eligible candidates for the reasons already discussed here and before. Paragraph. For the aforementioned reasons, the court is unable to find an error committed by the learned single judge in passing the impugned judgment and issuing the directions as contained therein. Full stop. No grounds are made out for interference. The writ appeals are dismissed.
My lord, one submission, my lord. My learned brother intimated that that amendment which is brought in is under challenge before the Honorable Supreme Court.
Correct.
Validity. Obliged, my lord.
And I think our judgment has been stayed.
Yes, ma'am.
It has not come up after that, I think.
No, it's going to come up in third week of January.
Supplementary list item number 9.
May I please, Your Lordship? This appeal against the order of the Honorable Single Judge.
Your Lordship, on behalf of Mr. Rath, he is requested for a passover.
All right. How much is the delay?
Delay, my lord,
7 days. All right.
yes, ma'am, 7 days.
Pass.
Item number 10.
May I please, Your Lordship? Yes. So appeal is directed against the order of the Honorable Single Judge at Annexure 6, page 59, wherein he is directed to extend the benefit of UGC scale of pay to a teacher who was working in a Sanskrit school as a teacher in Orissa. And accordingly, he is also directed to not only pay the area salary from the date to the 1989 and also pays interest at the rate of 6%. But some dates are very relevant for this purpose of adjudication of this case. But in fact,
So have you implemented the order, sir?
no, Your Lordship have been pleased to stay the order.
Oh, the contempt case.
Yeah.
All right. Yes.
She was appointed as a teacher in one Samsundar Sanskrit College, Bhograi, in the year 1984, 26/11/1984. The post occupied by her was approved by order dated 10th of March 1990 for direct payment of salary with effect from 4/6/1986. And this thereafter, Your Lordships, the Department of Higher Education by resolution dated 6th of October 89 issued a guideline for extending the benefits of UGC scale of pay to the teachers of different colleges. And this aforesaid resolution specifically stipulated the category of colleges, institutions to be covered under the said resolution. And that para 3(1) of that resolution reads coverage. The revised scales and other measures for improvement of standards in higher education shall be applicable to all categories of full-time teacher working in all affiliated government colleges and aided government colleges, either covered or eligible to be covered under direct payment scheme till the 1st of April 1989. The scheme also will also be extended to full-time eligible teacher working in colleges of accountancy, management studies at Cuttack. And thereafter, in this resolution, the word or term college was never defined, so it was subsequently clarified that under these instructions shall mean aided colleges which have been given government concurrence and university affiliation for opening of +3 courses by 1st of April 1989 and not thereafter. Subsequently, in the year 1992, that is 3rd of January 1992, the government decided like this, the institutions imparting education
up to Shastri level were considered as schools and not as colleges, and Government of Odisha in Education Department by notification dated 31st of January 92 brought Sanskrit institutions imparting education up to Shastri level at par with degree colleges. So our case is that because she became eligible to be considered a teacher or lecturer in a college with effect from 1992, the benefit under this 1989 resolution cannot be extended to her.
Why? It is a college, right?
No, it obtained the status of a college by virtue of the resolution of the state government in the year 1992. But the benefit of UG scale of pay was extended to lecturers or teachers in the colleges with effect from 89. So she is not entitled to cover under the because it's a one-time measure. Those who have got direct payment and have got the requisite qualification prior to 1989, they are eligible to get the UG scale of pay, not thereafter. So
no, but she got her qualification and all from 87 itself, right?
No, qualification is not under challenge. Our case is that she is working in a Sanskrit school, which is not a college, and the resolution of the state government extending the UG scale of pay as per the UGC guidelines is applicable to the colleges only. She is not entitled to that because subsequently these Sanskrit institutions which are imparting education up to graduation level were brought under the fold of college with effect from 1992. That is our case. So she is not entitled to UGC scale of pay.
No. So she's already working in that school from 87 onwards.
Right.
So from 92, it becomes a college.
Yes.
So once it has become a college, why should she not get the UGC scale of pay?
The Honorable Single Judge has directed Lordship may kindly come to Annexure 6, page 59.
Right.
The concluding paragraph is at page 68.
Right. At 12.
Under the circumstances for the clear position in the resolution dated 6th of October 1989, the development taking place through the documented Annexure 7, 8 and legal provision indicated herein about, this court finds the impugned order right Annexure 5 remains unsustainable. This court therefore interfering in the impugned order at Annexure 5 sets aside the same and while allowing the writ petition directs the opposite party 1 and 2 to grant the benefit of UG scale of pay to the petitioner with effect from her appointment since her eligible to with effect from 1/6/1987.
No. So you are okay to pay her from 92?
That in fact, that we have not considered.
No. So your only problem can be 87 and 92. 92 it becomes a college. She's anywhere entitled to UGC then. So we limit it to 92 onwards. So you're for the teacher. You're for the.
And the interest of 6%.
Just come to the mic.
Microphone. And the interest of 6% has been granted to with effect from 1987.
It is a school that they say it is a college, and she is a lecturer, not teacher. Notification dated 31.
What do you say, sir?
Sir.
What do you say to this? That the school became a college in 1992. What do you say to that?
No, it got affiliation 86.
It got affiliation as a school.
No, school no. It was 86. It got affiliation as a college.
What is the document to show that?
University.
What is the document to show that? Show us the document.
Approval order. Approval and Annexure 1.
Annexure 1 to what?
Approval order is that shows the one's in pursuance of geo number at the GOICS dated 11/7/89 and number at the dated 6/26/10/89. Approval is hereby recorded provisionally to the appointment of the following teaching and non-teaching staff of Shyamsundar Sanskrit College, Bograi, in the district of Balasore.
So it was already a college?
Yes. And it is from 86. And it is
from
serial number 3. Jaishi Sharangi for soccer. Please hear me. Just
so where have we stopped you?
No.
We are asking you questions and suddenly you're saying, please hear me.
I'm reading out. I'm reading out.
We want you to argue, sir.
No, yes, sir. So this is the approval order, and the annexer 6 copy of the resolution 6/10/89 dated 6/10/89 of Government of Odisha. So the notification dated 31/1/92 is not applicable to the respondents' college, as the Shastri course of the college got affiliation with effect from the academic session 86/87, making it a degree college. This has been mentioned in para 3 of the writ appeal. They have mentioned in the writ appeal that it has got affiliation with effect from 86/87. The respondent's post as lecturer was approved with effect from 1686 by order number 8750 dated 14/3/90 of appellant number 2, where approval was accorded to the appointment of the respondent for direct payment of salary cost according to the granted principle of the appellant number 2. That the respondent's post as lecturer was admittedly approved on 1686 by appellant number 2 much prior to the cutoff date for entitlement of UGC scale of pay according to the resolution dated 6/10/89 issued by the erstwhile Education and Youth Services Department, Government of Odisha. The resolution dated 6/10/89 is enclosed as annexer 6 of the writ petition. That in view of the aforesaid ground, the respondent is justly and rightly entitled to the UGC scale of pay, as her post was approved on 1686. The cutoff date for granting the said scale of pay being fixed as 1/4/89. The explanation is given in para 12 of the writ petition. That the statutory status of Shyamsundar Sanskrit College, wherein the respondent served as lecturer and later as principal, is spelled out in clear terms under Orissa Education Act 1969 as enshrined in section 3B and explanation thereto. The relevant portion of Orissa Education Act 69 and the explanation thereto is elucidated in para 14 of the writ petition. Also, this find mention in para 11 of the impugned judgment that the much vaunted notification of dated 31/92 of Government of Odisha Education Department is redundant one in that the provision with the similar purport existed under the Odisha Education Act 69 as outlined in the foregoing. A Sanskrit college of our state, in accordance with the cited provision, automatically acquires the status of a college, degree college, or in other words, it becomes equivalent to a general degree college as and when teaching provisions are made therein for imparting teaching for Shastri degree course of Sri Jagannath Sanskrit University, Puri. On the other hand, the cited notification dated 31/92 is a nullity in the eye of law, as it happens to be a directive of the executive having no legal sanction. It contravenes the spirit of the aforesaid statutory provision, since it arbitrarily fixes a date for according equivalence to a Sanskrit college, even if the same had already acquired the status of a degree college prior to the said date. It is a truism to say that an executive order is subservient to a statutory provision like the one enshrined in section 3B of the Odisha Education Act 1969 framed by the legislature. It already existed.
Sir, are you in a position to answer some questions, or we should not interrupt you? Are we permitted to ask you questions, sir, with your kind permission, or we should not ask you questions?
Yes, sir. Yes, sir.
What yes means what? No. Do we have your permission to ask you questions?
Yes, sir.
Now this resolution that you pointed out, Annexure 1 to the writ petition, please come to that.
Annexure 1. Yes, sir.
Kindly tell me from that annexure 1, does it talk about granting UGC pay scale to your client?
No, it has not been granted. That is why it is under challenge.
All right. So
similarly placed.
So what do you have to say to the contention that the eligibility to be granted UGC pay scale was brought about only in 92?
No, it was in 89. Resolution annexure 6.
Annexure
6.
Ah.
That my friend read out.
That is also available at page 15 of my writ appeal. Page 15, the resolution of the UGC.
Yes.
The question of revision of pay of college teachers on the basis of recommendations of the Government of India, para 3, was under consideration of the government for some time past. After careful consideration, the state government have been pleased to decide to implement the scheme of revision of the scale of pay of college teachers with the following terms and conditions. The revised scales of pay, other measures for improvement of the standards in higher education shall be applicable to all categories of full-time teachers working in all affiliated government colleges and aided non-government colleges earlier covered or eligible to be covered under direct payment schemes till the 1st of April 1999. The scheme will also be extended to full-time eligible teachers working in the college of the accountancy and management studies specifically, which were limited to.
Also, no. The scheme will also be extended.
Right,
it's not only for accountancy studies.
No. I say colleges and only accountancy. So Sanskrit was never included here.
No. Don't read it like this, sir.
Yes.
The last sentence which talks of College of Accountancy and Management is an also preceded by the scheme will also be extended.
Right.
The earlier lines are not exclusive to non-Sanskrit. Where do you get all that from the earlier lines?
I'm saying not Sanskrit. I say it's colleges and accountancy and management studies.
Sir, you forget now accountancy and management.
I am not there.
Don't go on accountancy and management. This is not an accountancy and management college.
Right.
Keep that out.
Right.
Read the first 3 lines.
Yes, The revised scales of the measures for improvement of standards of higher education is applicable to all categories of full-time teachers working in all affiliated government colleges and aided non-colleges either covered or eligible to be covered under the direct payment schemes till 1st of April 1989.
So this, what she is working in is a non-aided college, Sanskrit college.
Aided.
It's aided. All right. Aided Sanskrit college.
That's what I'm saying. It's not a college. It will be fortified by page 27 annexure 2 Yellow Calcon 2.
Yes.
Page 27. The question of deciding and declaring equivalence of Sanskrit institutions imparting education up to Prathama, Madhyama, Upasastri and...
Page 27 of?
My brief, writ appeal.
That is annexure 7.
Yes,
page 27 of your
writ appeal.
Okay. Yes.
It's a notification dated 31st of January 1992.
Right.
The question of deciding and declaring equivalence of Sanskrit institutions imparting education up to Prathama, Madhyama, Upasastri and Sastri level was under consideration of the government for some time past. After careful consideration of various aspects of this question, government have been pleased to decide as under institution imparting education up to Prathama, its upper primary schools, institutions imparting education up to Madhyama level secondary schools, and institution imparting education up to Upasastri higher secondary schools, institution imparting education up to Sastri level are deemed degree colleges. So I say, from 1992, the educational institutions imparting education in Sanskrit having up to Sastri level equivalent to colleges with effect from 1992 only, not prior to that date. That is my case. So if at all she will be eligible, then only after 1992, not prior to that date.
She was appointed as college lecturer in 1986, before cut-off date, 89. So it is applicable to other colleges, not to this college. Newer colleges, but these colleges, she was approval order shows, and she got a lecture. She was a lecturer.
Up to what level was the teaching happening in this college where she was appointed? Were they teaching up to Shastri level?
She was a lecturer.
The college, sir. What about the college itself? Was it imparting education up to Shastri level?
Yes.
Where do we get that?
81 got affiliation from the Sanskrit University.
No.
And she.
So you're not answering the question whether it was offering education up to Shastri level.
Yes, my lord.
No, what is there to show that? University granted affiliation. Let's see, next 3. What is their college? Sham Sundar. No?
Sam Sundar.
So the affiliation was granted from 81, 82 itself. The affiliation to as a college was granted in 81, 82 itself. See, this notification which you're reading, you yourself issue a notification. And only generally saying that if you have offered courses up to Shastri level, you will be considered a degree college.
Right.
But that does not take into account colleges that have already been declared as colleges. This is institutions which have not yet been declared colleges. So now you're saying these institutions, if they offer up to Shastri level, we will call them degree colleges. But if there are institutions which are already colleges, how can that apply?
The equivalence of the course was in question marks, and they were not getting the same scale of pay as in the degree colleges. That is why this 92 reason came. It was
before that college.
It was a college much before, sir.
No, college was established.
So only for those institutions which are not yet declared as colleges, that notification will apply. For institutions which are already colleges, already got affiliation, where's the question of that notification applying?
No. Yes, I could not hear.
Page 15, Annexa 3 of the writ petition. Please.
Correct.
So that is the 18983 affiliation order.
Yes. That is by university.
Yes. The Sanskrit University
which recognized as affiliated as college.
Yes.
Not as school.
So
she has been appointed in college.
Yes, nomenclature as college is not disputed, So far as nomenclature.
No, it is in fact, it's not mere nomenclature. It is actually a college, which is why it got affiliated to university. How can they affiliate a school to university? They can't affiliate a school.
Yes.
Only a college can get affiliated to university, sir.
So it is not under Board of Secondary Education.
No, up to Madhyama, it's under board, and prior to that, Sanskrit, it's definitely a college.
Yes. It's from 81, 82 itself.
Even annual report also included.
Yes. All right. You said the challenge in the present writ appeal.
The other question was granting of 6%.
Yeah, that's okay. That's all very nominal.
Because your lordship, she came to the Honorable Court in 2012 after making a representation. There is no fault on our not denying her.
What is it? No fault. Unless people ask you, they won't give it, is it? You should have given it to yourself without them having to ask. You see, the challenge in the present writ appeal is to a judgment dated 27th March 2019, passed by the single judge, allowing writ petition civil 20728 of 2012 filed by the respondent and directing the appellant to grant the benefit of UGC scale to the respondent with effect from the date of her initial appointment as lecturer in Sanskrit with effect from 1st June 1987. So the arrears were to be released in favor of the respondent within a fortnight. The benefit had to be, the arrear of the benefit had to be calculated within a period of 6 weeks and released in favor of the respondent within a fortnight thereafter, together with 6% interest, simple interest per annum. Paragraph. The background facts are that by an audited that the respondent was appointed as a lecturer in Odia in the SS Sanskrit College, Bhogaraj, District Baleshwar. From 1st June 1986. And the said post became eligible for a grant from 1st June 1987. Full stop. The provisional approval for such appointment was issued by the Director Higher Education Orissa on 14th March 1990, acknowledging the said institution SS Sanskrit College, Bhogaraj, to be an aided college. Paragraph. It appears that prior thereto, on 4th October 1983 itself, affiliation was granted through the said college by the Sri Jagannath Sanskrit Vishwavidyalaya, Puri, for the academic session 1981-82 and 1982-83. Full stop. While the above was a temporary affiliation, permanent affiliation was granted to the same Sri Jagannath Sanskrit Vishwavidyalaya, Puri, on 6th January 2011. Full stop. The college offers a 3-year Shastri degree course with effect from academic session 1986-87. Full stop. The petitioner's claim for UGC pay scale was rejected by the appellant by an order dated 22nd September 2012. reliance is placed on para 3.3.1 of a resolution dated 6th October 1989 of the Education and Youth Services Department, Government of Orissa. Not 3.3.1, just 3.1. As regards extension of the UGC pay scales to college teachers. Stop. The set para 3.1 reads as under. Take from page 22. Sorry. Yeah. Take from page 15 of the writ appeal. Paragraph. According to the appellant, although para 3.1 did extend the UGC pay scales to full-time teachers working in all affiliated government colleges and aided non-government colleges, it was only by subsequent notification dated 31st January 1992 issued by the Education Department, Government of Orissa, that the SS Sanskrit Vidyalaya, Bhogarai, was recognized as a single course degree college. Paragraph. What above notification dated 31st January 1992 does is to communicate, is to notify the status of the institution imparting Sanskrit education. Full stop. It obviously applied to institutions which had not yet been declared as colleges. Full stop. In other words, it did not apply to institutions which were already colleges and which stood affiliated to universities. So in the present case, as already noticed, the SS Sanskrit College was granted temporary affiliation from the academic year 1981-82 to the SJSU Puri and permanent affiliation by the notification dated 6 January 2011 of the same SJSU SV Puri. There was no question of affiliation to a university without the institution being a single course college, unquote. In fact, in all the notifications of affiliation issued by the SSJV, the reference to the SS Sanskrit Vidyalaya is as a single course college, unquote. Paragraph. The court therefore is of the view that para 3.1, but that the SS Sanskrit Vidyalaya already stood covered by clause 3.1 of the resolution dated 6th October 1989 of the Government of Orissa. Paragraph. The learned single judge has come to the conclusion on the strength of the above resolutions and notifications that the institution in question ought to have been granted the teachers of the institution in question ought to have been granted the UGC pay scale. Since it stood covered by clause 3.1 of the resolution dated 6th October 1989. This resolution of 6th October is prospective or retrospective?
Prospective as well as retrospective.
Okay, it be both, sir. It can be only one.
Now it is effective from 1/1/89.
89.
1/1/86.
1/4/89 or 1.
Yes.
Now 86.
No, the resolution dated 6th October 89, sir. It's effective from which date?
No, 1st of April 1989. That is the cutoff date.
Cutoff date.
No, that's the cutoff date for being granted the UGC pay scale.
But the resolution.
But from which date will it be granted?
The resolution 1686. Now 186.
Where do you get that?
That is.
3, para 3.4. In terms of para 3.4 of the.
So it is from the date of
resolution. So that's the answer, sir. Now I've pointed out. In terms of para 3.4 of the same resolution, the UGC pay scales were admissible as on 1st January 1986. Stop paragraph. Accordingly, the court finds that the learned single judge has committed. There is no legal infirmity in the impugned judgment single judge granting the aforementioned relief
3.49
of extending the benefit of UGC pay scale to the respondent from the date of her initial appointment as such. That is June 1987. And with the arrears having to be paid with simple interest at 6% per annum. Paragraph. There's no merit in the present appeal in its dismissal. The interim order is vacated. The delay is condoned.
Supplementary list item number 11.
So, allowed, my lord.
Allowed me this week.
I am for the union of PTI.
For extension of time.
Dismiss.
You have to speak louder, sir, into the mic if you do not mind.
Obliged, my lord.
My lord, the sole prayer of this PIL was to extend time of GSTR for 9 and 9C.
Now, who's for the petitioner?
Petitioner is not there.
None appears.
It has already become infructuous. That is what.
All right. None appears to the petitioner. Council of the Union of India submits that the prayer has already become infructuous.
My name may kindly be.
Your Lordship,
appear.
I'm appearing on behalf of Mr. Jena, who has requested for a passover.
All right.
On the matter.
Passover.
Thank you.
Item number 12.
My lord, on behalf of Mr. Rai, is in accommodation. Let it complete, my lord.
All right. Mr. Rai is stated to be unwell.
Entry
Sorry,
order-
not in some personal difficulty today. List on 6th April.
Interim order to continue.
All right. Interim order to continue.
Item number 13. Item number 13.
None appears dismissed.
Item number 14.
Item number 14, I have been instructed by the petitioner to appear before the Lordship. Today I have been instructed a short date may be given.
Where is your Vakalatnama?
On the day, tomorrow I'll file the work.
What's his name? Mr. AKD appears on behalf of petitioner and states he's been instructed recently. And wants an adjournment. Based on 20th April.
Item 15.
Yes, I have entered appearance in this case, my lords. There are two defects, my lords, which are trivial, my lords. One is Bhakalatnama not duly executed, your lordship may permit me, so that can be done, my lords. And other one is translation copy, my lord.
This time was already sought in February 2020, sir, almost 3 years ago.
No, sir, that may be ignored, my lord, because the sestat order, my lords, the first page is Hindi, that has nothing to do with the ordering portion, my lord. That is only, my lords, instructions. So that can be ignored, my lords. And if you permit me, I will proceed, my lords, the matter.
No one has appeared to press the appeal, nor defects pointed out. Same problem there also, sir. In Sestat also, defects not removed.
No, Sestat, milords, what has happened, milords? It's in fact, bizarre case I find, your lordship will find it. What has happened? The show cause notice issued to 6 numbers of companies. 6 numbers. And when the act itself bears definition of person, it cannot be, milords, assessment in respect of 6 persons in one go in one order. And order is also passed in respect of 6 persons, 6 companies in one, milords. And your lordship may kindly think of supposing now there is a demand. And in the meantime, during investigation, I had paid about 10 crores and that is mentioned in the order itself, adjudication order. Almost more than 11, 12 crores has been paid. And so far as there are 2 defects, the Lorraine Tribunal has pointed out. One is pre-deposit. Pre-deposit, as my lords will understand 86 to maintain appeal, I have to pay 10%, 7.5 plus 2.5, 10%. And the amount which I have paid is much more than what is required to be paid. And secondly, the other defect is resolution. If 6 companies are there, can there be, I have mentioned in paragraph 14, your lordship will kindly see the pleadings. Paragraph 14, I have, this is an incurable defect pointed out by Lorraine Tribunal. There cannot be resolution of one company in respect of 6 others. That is not possible. They are incurable. So therefore, this goes to the very root of jurisdiction.
How much pre-deposit payment? How do you demonstrate that?
I have demonstrated. Your lordship kindly see page 66. Page 66. Page 66. This is an adjudication order where in paragraph 10. During investigation, Sunil Kumar Shah accepted the liability of service tax in respect of subcontracting party.
Pre-deposit for the appeal is different from this, sir. Please.
Sorry, milords.
Pre-deposit for an appeal before the Sestat is not the same as deposit of service tax. This is different. Let's be clear on this. You may pay so much tax, you may not pay.
Judgment of Honorable Apex Court.
Yeah. That's different from this pre-deposit for the purpose of appeal.
No, pre-appeal, but to maintain appeal, milords.
I have take the adjudication order, you see what is the demand.
Correct.
On that basis, you have to pay pre-deposit.
Correct, milord. And Honorable Apex Court said
you can't say, no, during the adjudication period itself, I paid so much tax, that is good enough for the pre-deposit. You cannot say that.
No. What I am submitting, Honorable Apex Court said that if money is paid, milords, during investigation before passing of adjudication order, milords, these are not, milords, matters left to, milords, depositing while filing return, milords. Milords, post and in course of investigation, if some amount is paid under protest, milords, forcible collection. Your lordship also in one case directed refund, and your lordship will kindly see page 9. But I have gone to Madras High Court, and what Honorable Madras High Court had said, my lordship will kindly see page 9, milords. Just 4-5 lines I am reading. Page 9 of my petition. It is also pertinent to submit here that the opposite party number 3 has collected a sum of rupees 10 crores deposit in JR1 Chalan from Sunil Kumar Shah, which is contended to be volunteer payment as part liability of service tax for the past periods. The details of which are mentioned in para 2.4.4 of show cause notice demand notice dated 14/4/15. A further sum of rupees 2 crores was also realized from Mr. Saha, said to have been paid on behalf of Chitra Builders, Coimbatore, for the past liability of service tax, which has directly refunded by the, which is directed to be refunded by Honorable Madras High Court in order dated 4/1/13 in writ petition number 2487 of 2012 as the collection of tax illegal and without jurisdiction. Because money is realized because that they don't have power, and there is no provision under Finance Act to collect
This
money.
is all merits, sir.
That's what I am humbly submitting, because these are expected order. If your lordship will relegate me to the Royal Tribunal, Millards, I will show evidence of payment. There is also a Supreme Court judgment saying
where
that,
shows the evidence of payment?
Millards, it is there, Millards. Your lordship will find page 66, Millards.
That is not the pre-deposit, sir, in the tribunal. Please, I'm repeatedly telling you, you're confusing between what you pay during adjudication with pre-deposit to be deposited in the tribunal.
But that is what I am submitting, Millards. Honorable Apex Court said any amount paid, Millards, during investigation before adjudication order to be treated as considered as pre-deposit, Millards.
Where is it?
Yes, Millards. Because that is Supreme Court decision in Manu citation, Manu SC 1235, 21, VBF India versus State of Maharashtra, paragraph 11 and 12. Same situation as Arijan.
We don't have a photograph. Unfortunately, our memory is very poor, sir. I'm not able to remember what this para 10 and 11 is.
Yes, sir.
Without a copy, I can't remember what 10 and 11 is.
Kindly permit me. I am extremely sorry because yesterday I had some difficulty.
Whenever you want, sir. Mr. Sahu wants to cite some decisions of the Supreme Court of India regarding pre-deposit for the purposes of an appeal before the SISTAT. At his request, list on. April.
Your Lordship, my appearance may be noted on behalf of the opposite party number 2.
Item number 16.
Yes, in this case, there is a noting they have filed counter, but copy of the counter has not been served on me.
Your Lordship,
and
sorry, I'll serve in course of day.
Issue involved, it's a claim of refund of 98 lakhs, Millards. So,
in course of day, I'm serving.
Arising out of export, and the only very interesting, only one point is involved, Millards. They say,
but you don't have the counter.
Yes, let me let them
copy
file.
the counter of it be served upon counsel to the petitioner during the course of the day. Then it be filed for the next date. 19th April.
Item number 17.
Item number 17, my lord. I am covered my lord's order dated 8th of December 2020, your lordships, in the WPC number 155322, your lordships, in the case of Adhunik Metal Links Limited, your lordships, wherein my lord has categorically held that the demands prior to commencement of resolution of proceedings approved by NCLT shall be extinguished, your lordships, followed by the order of the my lords, followed the order of Ghanshyam Mishra and Sons Private Limited, wherein also the present petition is one of the party. Let me share the copy of the orders, my lords. In the above case, your lordships, the demand under the OET Act, CST Act, and service tax on royalty had been extinguished, your lordship. Demand has been set aside, your lordship.
Your Honor, let me take the instruction on this ground. Your Honor, they have challenges. They have not submitted. It is an appealable order. They have not submitted the document which was required to them.
I am coming to that, your lordships. I have obtained
page 167.
I have obtained license under EPCC, your lordships, on 23rd of March 10, your lordships. On the basis of EPCC license, I procured the goods under the bill of entry dated 31st of March 2010, your lordships. And I saved the customs duty without payment of customs duty. As per the export obligation, I have to comply within a period of six months, your lordships. 6 years, sorry. So the decision plans which have been approved on 30th April 2017, your lordships, as per page 41, your lordships, and this period of compliance obligation of the extinguished on 16th, your lordship. That is much prior to the initiation proceedings, your lordship. That being the case, your lordship, my demand is not sustainable, my lord.
Your Honor, in this case, they have moved to Supreme Court in a SLP number 7147 and 27150.
Yes,
and they were the respondent, they told. the respondent was only for the cell tax commercial department. They were not for the respondent was not, they were not the respondent in this case.
Ultimately, also
And
decided
Your
by the Supreme Court lordships against the demand under the Jharkhand Act that the amendment shall have a retrospective being a clarificatory in nature, my lords. So the demand could not be sustained. That's out of the Honorable Supreme Court, your lordships, in the Ghansam, Mr. Case, your lordships.
Your Honor, a short date may be kindly given to give an instruction. We had 5 appeal and in the two of the cases,
Let me give you a chart.
Satpathy is going to appear.
Sorry?
There are 5 cases. In 2 cases, Mr. Tushar Kanti Satpathy is going to appear.
He is only there in all these other matters, sir. No problem.
In item number 18 and 19.
Yeah.
All the 5 minutes.
Correct. You see, admittedly, the resolution
Let me
plan with
verify
respect to the present
order.
petitioner was approved by the National Company Law Tribunal on 30th April.
On 17th of April 2018.
17th?
April 2018, my lord.
17th April 2018. Paragraph. As far as the impugned demands raised in the present petitions by the Customs Department,
My lord.
they all pertain to periods prior thereto. Full stop. With the resolution plan already having been approved, all liabilities of the petitioner prior to the aforementioned date of the resolution plan would stand extinguished in terms of the judgment of the Supreme Court of India in Ghanshyam Mishra and Private Limited versus Edelweiss Asset Reconstruction Company Limited, 2021 SEC Online SC 313. Where it has been held as under. Just take from this order. Paragraph. The above decision has been followed by this court in its judgment dated 21st June 2021. In repetition 8259 of 2019, bracket Messrs. Sri Metallics Limited versus State of Odisha. In that view of the matter, following the above decision, the court quashes all the demands challenged in these questions. They are accordingly dismissed.
18 and 19, Mr. Tushar Kanti Satpathy is active.
Only the name of Mr. Satpathy we included, 18 and 19.
And 17, 20, 21, I am appearing from.
Up to 17, 18, 19, 20 and 21.
Correct.
Item number 22.
I deeply obliged, my lord.
Pardon, my lord. I have misplaced the file. Your lordship may take it up tomorrow or day after, my lord.
All right. At the request of counsel for the petitioner. List on 27th January.
A copy may be served to us of our opposite party number 1 in item number 22.
Yes, I will serve today.
I am appeared from the opposite party number 1 for item number 22.
All right. All right.
Supplemental list, fresh admission item 23.
The matter become infructuous.
Okay. Dismissed as infructuous, both matters.
Item 24.
None appears dismissed.
Item number 25.
24 to 27, it is the 8 and the 3-day delay for behalf of Siddharth Shankar Mahapatra, Senior Standing Counsel. I am submitting the memo of appearance. 24 to 27.
Okay, 24 to 27, you say all these applications are delayed by over 800 days. And the delay has not been satisfactorily explained. In fact, steps have also not been taken. The applications are dismissed.
Item number 28.
May please move. CMAPL for restoration. Dismiss for default. Date chart for delay condonment.
All this is not valid. What's the delay? Yeah.
517.
There's an inordinate day of 517 days. 517 in filing the present application. chart handed over in court as explanation for the delay only states that matters could not be followed
My lord, in
followed
this
up due to
case,
change of standing counsel. Full stop.
My lord, in miscase para 3 already explained the
Very good. Very
regarding delay, my lord.
All right. The explanation offered is totally unsatisfactory and not convincing. Following the decisions of the Supreme Court of India and Director General Postmaster, Postmaster General versus Media and State of Madhya Pradesh versus Berulal, the delay is not condoned. Accordingly, the application is dismissed.
Item number 29.
None appears dismissed.
Item number 30.
None appears dismissed.
Item number 31.
No instruction. No instruction dismissed.
Note 32.
None appears dismissed.
Item number 33.
My lord, permitted to withdraw, my lord.
Dismisses withdrawn. All right.
Item number 34.
Permitted to withdraw, your lord.
All right. Dismissed as withdrawn.
Item 35.
None appears dismissed.
Item number 36.
Item 36, my lord. By the order dated 15/12/2017, notice had gone. Nobody has yet appeared.
Let's you come to the merits.
Sorry. My lord, the dismissing the writ petition, your lordship will find at page the impugned order before. My lord, may kindly take page 28. Taking into consideration the clarification made by the government in School and Mass Education Department by its letter dated 2/12/2015 and in the 2008 rules, it was specifically stipulated on completion of service in their original post or grade. Rightly, the tribunal has passed the impugned order. My lord, the 2/12/2015 letter was issued by the department with regard to the clarification concerning RACP. Here the claim of all the opposite parties before the tribunal regarding grant of ACP. For ACP and RACP, that rule, your lordship can have a glance, that rule is there in the writ petition. We had annexed it in the writ petition, page 75.
So the dismissal of the writ petition by you was in the year 2017.
Yes, madam.
What has happened since then, sir? So this was affirming the order of the tribunal.
Yes, madam.
And the tribunal's order must have been some 2016 or 15.
2015,
9th January 2015.
Yes, 2015.
And there has been no stay in the review petition.
Question of law.
We'll leave it open. You say no grounds are made out for review. Questions of law, if any, arising from the original order of the tribunal are left open for decision in some other appropriate case. All right.
Up to item 40, all are.
Oh, I see. All right. Up to item 40. All right. Item 40, yeah.
Item number 41.
None appears dismissed.
Item 42.
Delay. So 42 is also yours.
Mr. Mahapatra.
Again, same thing. So delay is not condoned. In any event, the question of law arising is left open for decisions of other appropriate case. All right.
Item number 43.
Yes, I'm sorry, my lord.
Delay of 100.
That's okay. We've dismissed it now. Leaving the question of law open. All right.
Item 43. With your lordship's permission, can I pray for 2-3 days adjournment, my lord?
No.
In fact, my file is misplaced.
That will be even more convenient, sir. Whenever you get the file, you revive it.
I have got a copy of the petition from my computer.
So you're very kind. No problem. If you want to argue on that basis, argue. If you say brief is missing, we'll permit you to revive it whenever you find the brief. You'd want to do.
There is a delay of 9 months, my lord.
So you are providing us more ammunition now. So we'll dismiss it on delay then. All right. It has an unexplained delay of 308 days in filing this review petition, which has not been satisfactorily explained. Accordingly, MC number 233 of 2017 is dismissed. Consequently, review petition is dismissed. All right.
Item number 44.
Item number 44, my lords. I today appeared for the respondent members, item number 151 of 2018, my lords.
Yes.
I request him to serve a copy on me. On 12/12, they have highlights, but on instruction, I'm appearing today.
All right. Mr. Patnaik accepts notice on behalf of the Cuttack District Tennis Association.
Yes, my lord.
All right.
I'm filing my vakalatnama.
What about cricket? Who's for cricket?
My lord, on behalf of Mr. Rai, he is appearing for the respondent. Let it come next week, my lord.
Which respondent?
That is Orissa Cricket Association.
Cricket Association. All right. Mr. Siddharth Rai, Learned Counsel, appearing for the Orissa Cricket Association, stated in some personal difficulty. So, list all these cases on 25th April.
25th April.
Item number 45.
Deep level. Lordship, petitioner has appointed a senior counsel who has his daughter's marriage on 28th. So, request the matter to be taken up after that.
Which name of the senior, sir?
Senior counsel, Mr. Vivekananda Mahanti.
See, at the request of his name is not shown in the cause list at all. Are you appearing the right matter? Which is the number of the matter you are appearing?
45 and 46.
No. What is the
item number 46?
You are not yet filed for Vakalatama.
No, sir, I am appearing for this time.
No. What is the item?
Item number 45.
No. Give us the case number.
It's Utkal.
You must have the file of some case, correct?
Yes. Utkal Pharmaceuticals.
Yes. And then next one is
46 also.
Come up.
Have you not yet filed Vakalatama?
No, sir. It is in dispatch. It has been dispatched. It will come by post.
All right. It is stated that, but obviously senior counsel cannot be Vakalatnama. Who's the instructing counsel? Who's the counsel who will file the Vakalatnama?
Mr. Pati had filed it. He had.
No.
Who will now file it, sir?
Mr. Vivek Mahanti, senior counsel.
Yes.
Who is his instructing counsel? Whose name will be recorded?
Mr. Jena, I guess. So this is the first time I haven't read the file.
This is the name of the counsel, sir.
What is your name?
Adhiraj.
Adhiraj Mahanti.
Yes, your lordship.
Okay, Mr. So-and-so. Advocate appears and states that he has recently been engaged and he will file his Vakalatnama for the petitioner within a week. At his request list on 20th April. Both matters. 45.
Item number 47.
My lord, item number 44. It's adjourned. Link was not there.
Please enter Mr. Chimanka's name in all matters.
Item 47. Sir.
Yes.
Your Lordship, in this case, Your Lordship may kindly come to the question of law.
Yes.
At page 43, Your Lordship. The Learned Tribunal has deleted the interest, deleted the penalty. Everything has been deleted since the issue. This is that anti-tax matter, Your Lordship. So far as the levy of interest and penalty on two-third amount, Your Lordship. And during since the matter has been pending before Honorable Supreme Court, so everything has been deleted by the tribunal. So against that, state has filed this revision petition, which may be admitted because so far as that levy of interest, Your Lordship, that on 16th.
Or simply list on 16th. All right. List on 16th.
Or Your Lordship can admit this matter And when the question of law, and it can be decided after 16th, your lordship, whatever the decision.
We'll be there with 16th. We'll know. Ultimately, everything depends on what Supreme Court decides. All right.
Item number 48.
None appears dismissed.
Item number 49.
Yeah, same.
Item number 50.
Same.
Item number 51.
Same.
Item number 52.
My lord, appearing for the petitioner, my lord.
Yes.
The question of law is on page 30, my lord. Two questions are framed, your lordship. Page 30, my lord, 30.
Yes.
My lord, one is, it is escaped assessment after audit assessment. So my submission is that there was a change of opinion. The authority did not have jurisdiction under 43(1) to reopen the assessment, because at the time audit assessment, all these claims were before him. There is no fresh material. This honorable court in the case of Sarda Mines has already held, when there is no fresh material, it would amount to change of opinion.
Right, we'll just issue notice. Notice, he accepts notice. The record of assessment be requisitioned for the next date. List on 27th April, sir.
My lord.
Item number 53.
Oblige, my lord.
None appears dismissed.
Item number 54.
May I please, Your Honor? This petition has been filed by the petitioner who is an advocate of this Orissa High Court, challenging the collection of double toll fees in toll plazas for having no FASTag. So that I have prayed in this petition that at least one lane should be kept for cash lane, so that it is of no use double the amount.
Madam, let him first make a representation. You know, and this has been on since 2021 February. And
Yes,
we are now in December 2022. So
Yes,
many
ma'am.
people have obeyed this rule.
Many have also paid double the amount. This petitioner, most probably, he has filed the receipt that 4th of December, while he was coming from Puri, then double collection. Yes, my lord, I have also suffered. But being an advocate, we do not find time for our own cases, so that I have not filed. But it is the voice of all that it should not be. Because India is a welfare state. It is an exploitation, directly exploitation by the government.
Very interestingly, we did one comparative study for something else. And we found that India is the only country where litigants pay for lawyers' welfare. Are you aware of that? No other country, litigants pay for lawyers' welfare.
In the position of lawyer,
That's what I'm saying. That's what I'm saying. As it is, lawyers, yeah, a lot of welfare is being done for lawyers by litigants.
But not by government.
No, not by government, not by government.
Advocates.
No, not by government, not by courts, not by other lawyers, but only litigants.
Only
litigants. And also welfare for senior lawyers. Have you heard of that? We have a senior lawyer welfare fund. Have you heard of that?
I need not explain your lordship once.
No, I don't know.
How things are done.
I don't know. So in world over, you just see who pays for lawyers' welfare? Litigants paying for lawyers' welfare. Have you ever heard of it? You know how much welfare stamp is
no sympathy by anybody towards advocate, but it should not be expected from your lordship, my lord, being a part of this one. Your advocates used to think about all, but nobody thinks about that. And your lordship knows the position of advocates. Nobody thinks no money. How if the
how much? Just tell me how much.
The family,
even in this petition, how much welfare stamp? Can you tell me? How much welfare stamp has been played?
As per the law, I have paid much.
Any one of you tell me on an average on a petition how much welfare stamps are paid? Are you aware?
That 20
Many of you are filing matters, no?
Yes, ma'am.
Welfare stamp, tell me how much money?
Minimum 75 million.
It was 20, now it is 75.
And you're saying nobody cares for lawyers.
This is how much?
This is apart from fees. Sorry, yes. Justice Raman is right. This is apart from the fees for the lawyer.
Your Lordship knows Odisha is such a poor state.
No.
Here people
Compared to other states in Orissa, the welfare stamp for lawyers is much higher in Orissa than other states. And Orissa also we also collect senior advocates welfare. No other state in India has senior advocates welfare. It was it's such a revelation to me. See, we learn a lot every day. So
that should not be.
I
agree with that.
No, I'm not on should or should not be. I'm saying we have to be aware. That's all. What is being done for lawyers?
One thing that here only we pray that one cash line should be there for cash payment, because there is no reason why double the amount they will collect.
All we are saying is if a lawyer makes a representation, it will be taken very seriously. Correct? So you make that representation.
No, my lord, representation, nobody is here. The advocate's representation is not my personal experience. After 1.5 year only, even the FIR was not registered. I had to approach this honorable court. Then within 2 days, it was registered.
Okay.
And in spite of your lordships, that
so now with this order, armed with this order, you make the representation. All right. Then we'll see what happens.
Representation to whom I shall make, my lord, because there is no rules. It is only by way of verbal order this is done. In Bombay High Court, I have done some research work, my lord.
All right.
That Bombay High Court has issued notice and it is posted for hearing on this topic.
Okay.
And admittedly, there is a National Highway Authority having no rules. And without following any rules by some advisory and all they are collecting, that is unbecoming, my lord, in a democratic country, that without any rules, regulations, how they are collecting.
All right.
Because I could not find that rules are circular by which they are collecting. Only from the Google, I downloaded that only some information that from that day it is. But no, not a single scrap of paper I got it.
All right. All right.
Bombay High Court, they have taken up the matter and matter has been posted for hearing.
Okay. All right. So to whom do you want to make? You've made 4 opposite parties. You want to make the representation to NHAI or to State of Orissa? Whom do you want to make it to?
Who is responsible? It is so that state government is, because that works department, I got the that works department, they are also responsible.
No,
that is the part
Transport
of the government.
department must be.
Because there is a provision that we have to make any complaint, an appeal may be made to the works department. Who is most probably that superintendent
we'll leave it to you to decide.
Is in charge of
that.
We'll
leave it to you to decide. You say counsel for the
National Highway Authority, 3.
Concerned authority.
3.
All right. Counsel for the petitioner states that the petitioner will first make a representation to the concerned authority. And after following up on such representation, will seek appropriate remedies in accordance with law and accordingly seeks to withdraw the petition. The petition is disposed of, is withdrawn, if liberty is prayed for.
Opposite party number 3 may be mentioned. Otherwise,
anyway, so we've
from
said concerned.
I have to run.
No, concerned
Opposite
means
party number 3.
Concerned will include all, including all the opposite parties. Concerned authorities, including all opposite parties. All right.
Item number 55. May I please alert? Item 55 matter, PIL matter. My representation pending before OP number 2 since 12 September 2022 matter. Annexure 2 matter.
Encroachment on government land. Encroachment. Encroachment on government land.
PIL matter. Our land is part of the government taken the third party, my lord.
Who's
that reason we approach this honorable.
Correct. Who's the third party, sir?
My lord, some private person, the organization, so started.
So and so. So where have they been implemented, sir? Tell us. Come to the cost title. Tell us where have they been implemented?
No, my lord, I am approached the collector and
no, but in the petition itself, sir, you have drafted this petition.
My lord.
You only drafted it.
My lord.
Just show us from the cost title who is this third party.
Any other person or organization?
Where have you said that? Where see respondent number 3, opposite party number 3 is Tahsildar. After that, there is no respondent. Opposite party.
My lord, I have also approached the Tahsildar, collector also.
Correct, sir. But you have to not make name. You have to name.
Take care of the.
No, you have to name what you have to do, sir. All free legal advice. All right. You have to first of all name the so-called encroachers. All right. You have to mention their names in your representation. Then you have to make that representation. Then after waiting for some time, if nothing happens, you file the petition. In this petition, you must remember to make those parties also the parties. All right. Then we will entertain. All right.
But some more
so we are not charging anything, sir. Free legal advice. All right. Counsel to the petitioner seeks leave to withdraw this petition with liberty first to make a representation naming the so-called encroachers on public land, and after following up on such representation to seek appropriate remedies in accordance with law. This post office withdrawn with liberty.
Oh, please. Item number 56.
This matter, your lordship, may permit me to file appeal.
All right. Petitioner seeks leave to withdraw the present petition with liberty to file an appeal in accordance with law. If such appeal is filed not later than 13th February 2022, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition, should be considered in accordance with law by the appellate authority. Court clarifies it has not expressed any view in the matter. Originals be returned, subject to being substituted with attested photocopies.
Obligement.
Item number 57.
No instruction in the all right. Dismissed. No instructions dismissed.
Item number 58.
Lordships. In the appeal, I approached the appellate authority, my lord, to pre-deposit 20%. But due to financial dispute, I have not deposited. I approached, and this honorable court passed in so many cases, and there is an amendment on the VAT Act for to deposit 10%. So I lost this praise. Similar order may pass. I ready to deposit 10%. File statute appeal before the authority.
Lordship, this is pre-deposit, your lordship, that is mandated by the statute.
Whatever is mandated, correct?
I already been ready to deposit and approach the appellate authority.
Yeah, counsel petitioner states that he seeks to withdraw the petition with liberty to make the pre-deposit before the tribunal in accordance with the current statutory requirement. Dispose of is withdrawn with liberty as straightforward. Same order the next one, correct?
59.
All losses already deposited. In that case, I've already deposited losses.
Item number 60.
Item 60.
60.
I'm sorry. 60. Here, Lord, the GST matter where challenge the first appeal order, Lords.
So deposit 10%. Have you already deposited?
I've already deposited 10%, 20% of the remaining amount of tax.
All right. Because the GST tribunal is not yet in place, present restrictions entertained. Notice, Mr. Mishra accepts notice. Reply within 8 weeks, rejoined up to the next date. And in the IA, one that dispensing with is allowed. Then in the IA for stay, we say Mr. Karan, learned counsel for the petitioner, informs the court that during the pendency of the first appeal, 10% of the demanded tax was already deposited. Full stop. Accordingly, subject to the petitioner depositing 20% of the remaining tax.
Remaining amount of tax?
Yeah, remaining amount of tax within 4 weeks. No coercive steps will be taken against the petitioner during the pendency of the present petition. The IA is disposed of.
Your lordship, appearing for Tushar Gandhi Satpathy, his name will be deleted, lordship.
The name of Tushar Gandhi Satpathy be deleted and the name of Mr. Karan be shown in the brief.
I filed my appearance.
All right. 27th April.
Sorry.
27th April.
Malance. Obligement.
Item number 61.
Item number 61, my lord, on behalf of Siddhartha Mishra, sir. Permitted to withdraw, my lord.
All right. Dismissed as withdrawn.
Item number 62.
62 not pressed.
Not pressed, dismissed.
Item number 63.
Your lordship, the petitioner is a license holder for the beer parlor has applied to the authority to convert it to IMFL arms of as per the excise policy, my lord. And his application is pending, and as per the today's morning instruction, now it is pending with the government. It has been recommended for conversion.
All right. The petitioner's application for conversion of the license from beer to
Beer parlor to IMFL on shop.
from beer parlor to IMFL on shop is stated to be pending with the government. So if not already disposed of, then the said application shall be disposed of in accordance with law after hearing the petitioner, not later than 1st March 2023. And the order shall be communicated to the petitioner within a week thereafter. The petition is disposed of with the above directions.
Item number 64.
My lords. Item 64, my lords, is about illegal slaughter of cows in Cuttack city, particularly in 3 areas of Cuttack, Odia Bazaar and other areas. I think in last order, my lord, you had asked Lordship had asked CMC to file.
Unless there's some confusion, and fairly speaking, my lord, I got instructions to appear only last evening. I don't have a copy of the petition.
All right.
Obviously, it's there.
Or you take a soft copy.
My lord.
All right. Mr. Devashish Naik, learned counsel appearing for the Cuttack Municipal Corporation, states that he was instructed only yesterday to appear in the present petition. He is permitted to collect a soft copy of the entire petition from the question. Reply be filed positively on or before 1st February 2023. Rejoined that if any for the next day. List on 13th April.
Item number 65.
This matter has been infructuous, my lord.
All right. Dismissed as infructuous. All right.
Item number 66.
Sir, 66 may taken of 1 week after to file a rejoinder.
All right. Rejoinder to be filed for the next date.
Obliged, my lord.
13th April. All right.
67.
Item 67, my lord, I have already filed the rejoinder. And that is not on record, my lord. Also served a copy on the state, my lord. Because you may kindly say that.
Rejoinder be brought on record. List on again 27th April. All right.
Item number 68.
Hello, sir. Pleadings are not yet completed. We received only open number 3 and 7 counter.
I have filed my counter affidavit, my lord.
When?
I'm on the month of, my lord, I have filed it on 5th July. I am for temple administration.
You've got a copy of the counter?
Yes. Yes, I have already.
Okay, 3 and 7.
All right. Yeah. No, the state is also filed.
Yes.
We have not received.
You have to serve it on him.
Copy not received.
I will serve.
He said counter affidavit of opposite party number 2 be served on counsel with petitioner. Rejoinder be filed for the next date. 20th April. 20 April. All right.
Item number 69.
In 69, I am appearing on behalf of Omkar Devdas, my lord.
Yes.
In this case, the state has to file the counter, my lord.
Lords, item 69, although on the first occasion, my lords, we had appeared, but no copy has been served for some reason. It's not.
Copy of the petition be served on counsel for the state within 3 days. Reply be filed within 8 weeks. Rejoinder for the next date. List on 24th April. Defects be cured in the meanwhile. All right.
Deeply obliged.
Item number 70.
Item 70, Your Lordship, there are similar matters pending.
Your Lordship, that entity has interest and penalty. So let it be
16.
after 16 or 16.
16.
Obliged, Your Lordship.
Item 71.
71 not pressed, my lord. Both the cases.
All right. Dismissed as not pressed.
Item 72.
And Shah Mishra.
Yes, sir. May I please, my lord?
Yes.
Item 72.
Yes.
Yes, sir. Your lordship have decided in case of Bhushan Steel's case, my lords.
Yes.
Audit assessment scope, my lords. The assessing officer will not traverse beyond the audit visit report. If a lordship is in the language of 9C, my lords, the scope of audit assessment is on the basis report submitted by the audit team, and whatever there in the audit, my lords, that is to be taken care of in audit assessment, not beyond that. And here is a case, there are 35 lakhs is the entry tax, my lords. 35 lakhs they have reported here by Annexure 1. And the assessing officer has determined the turnover 559 crores, saying that the turnover which is, my lords, your lordship may kindly see, interstate sales. These are to be excluded for the purpose of entity tax payer. They has go out from the state millards. He has taken into consideration that turnover. But so far as millards, my export sales are concerned, I have me with a copy of millards CST assessment order. Lordship have taken into consideration millards while earlier order was while issuing notice millards.
A short adjournment, your lordship. This is the assess, your lordship already stays there.
Stay is there. Yes.
So your lordship, I may be permitted 2 weeks time to file
All right,
counter
despite
on these
6
particular
years,
issues, your lordship.
despite 6 years having elapsed after notice having been issued, no counter affidavit has yet been filed. Mr. Mishra prays for one last opportunity. The counter affidavit positively be filed on or before 1st March 2023. Rejoined the epiphany before the next date. Interim order to continue.
Deeply obliged.
Grateful, your
List on 26th April.
Item number 73.
My lord is directed to file counter. Till date, no counter has been filed, my lords.
So many MCs, sir. Further order regarding stay, further order regarding stay for appropriate orders. So 7971 of 2016 for the reasons stated therein, the applications allowed. The records of the case be kept ready for perusal on the next date. That's over. Then all that 12983, 20681, 21635. In view of the fact that interim orders are already continuing, they're directed to continue. Full stop. No further directions are called for as far as these applications. They are directed to continue during the pendency of the writ petition. Accordingly, these applications are disposed of. And then you say, counter has been filed by opposite party number 5, sir.
Yes, I have filed a counter under opposite party number 5. If you
My lord,
who else should file?
Lordship, see order dated, order number 8, dated 5 January, 5th January, 15th January 2018. Directed to obtain instruction to file counter affidavit, particularly related to Annexure 2.
My lord, if I may place your lordship, on 16/12/21, the lordships had asked opposite party number 6 and 7.
You say last opportunity, opposite parties 6 and 7 to file the replies within 8 weeks, rejoined for the next date. 25th April.
Interim order to continue.
Sir, after dictating all this, you're saying the same thing. What to do? Yes.
Item 74.
74 on behalf
Your
of
lordship, item number 74, I am
for the behalf of the department, at short adjournment where Tushar sir will appear in this case.
All right.
74 and 80 and 82.
All right. All these three matters at the request of counsel of the department. List on 25th April.
Item 74, I am for the
petitioner, my lord. Item number 80, I am for the petitioner. Interim order to be continued, my lord.
All right. In 80, is it?
80, my lord.
80 is interim order. All right. After lunch.
But in the instant case, the chairman has rejected my appeal by exercising the administrative power, my lord.
Oh, not a judicial order.
My lord?
Not a judicial order.
Not a judicial order. The tribunal who may reject the appeal or fix a date for hearing the matter.
So you were not heard when this order was passed?
Yes, my lord. I have not been heard.
Has to go back. All right. The impugned order, which is titled open quotation extract order from order sheet, that reproduce the whole thing from page 12.
reads as under. Then reproduce the whole order. It is not in dispute that the above order was passed on the administrative side. But give me that rule, sir.
95-4, my lord. 95-4, my lord. Rules. OBAT rules, my lord.
Chairperson of the Orissa Sales Tax Tribunal, Cuttack, and not on the judicial side. Stop. In other words, this was not an order passed by listing the case on the judicial side before the tribunal, but perhaps passed in the chamber of the chairman. Full stop. Paragraph rule 95 bracket 4 of the OVAT rules 2005 reads as under. Paragraph. On reading the order, it does appear that the registrar reported to the tribunal about the non-curing of defects. Full stop. However, the remaining part of rule 95 bracket 4, which enables the tribunal to reject the appeal or fix a date for hearing the matter and give notice for such hearing to the appellant in form VAT-504, was clearly not complied with. Paragraph. On that short ground, the impugned order is set aside. Essay number 33 bracket ET of 2016-17 is restored to the file of the tribunal, where it will be listed for hearing on 1st February 2023, on which date the petitioner will appear through an authorized representative. Paragraph. The tribunal will then proceed in the matter in accordance with law.
Let's see, let him remove the defect because he has not removed the defect. For non-removal of defect,
I will appear and remove the defect from that date, my lord.
Before that date.
Mr. Mohanty, learned counsel for the petitioner, states that the petitioner will positively remove the defects pointed out before the above date before the tribunal.
Obliged, my lord.
All right.
Item number 76.
76, my lord, the company has already been liquidated. And while others matter, my lord, while the liquidation process was under process, my lord, Lord has passed the following order. Now the liquidation part of it is over.
All right.
And the sales tax have also got its due, my lord. It's one of the rare cases. This was when the liquidation proceeding was on, my lord.
Oh,
now it's over.
Now in the department become vigilant.
Correct. In filing those claims. Correct.
In this case also we have raised our claim and also NCLT has approved the claim.
All right.
RP has accepted enter claim, I think.
All right. In respect of the same company, petitioner company, an order was passed on 24th February 2020 in Reputation Civil 4980 of 2018 as regards an assessment order.
For the period, my lord, 1/4/2010 to 31/3/2015.
Yeah, for the period 1/4/2010 to 31/3/2015.
Under the OVAT Act.
Under the OVAT Act. The present assessment order being under the... No, full stop. The said order notes that the petitioner is already under liquidation before the National Company Law Tribunal, bracket NCLT, by an order dated 3rd February 2020 of the said NCLT. Paragraph. The court is now informed that the resolution process has already concluded and the dues of the department have already been settled thereunder. That view of the matter, no further orders are called for in the present petition. It is disposed of.
You're obliged.
Right.
Item 77.
May I please? Here is playing in the financial department circular. Similar order may be passed.
Right. Same order.
Item number 78.
Lordships, I have already filed the rejoinder.
No, 1 minute. This is that Maji's case. Correct. Right.
I have already filed the rejoinder. During the course of in the course of the day, I'll give another copy.
All right. Counsel for the petitioner states that another copy of the rejoinder will be served on Counsel for the Union of India. Got we listed down for hearing or?
Lordships?
No, we listed for hearing or?
Yes, Lordships.
List for hearing on 20th April.
Okay.
20th. All right.
Item number 79.
May I please, Your Lordship? My Lord, I challenged an order of the initiating officer provisionally attaching my property under the Prohibition of Benign Property Transactions Act, solely on the ground that act will not retrospectively apply because it came in from 2016 and my transaction is 2001. Now the Supreme Court in a recent judgment has held that all confiscation proceedings cannot run.
My Lord, review petition has been filed on 31st/10/2022.
In the Supreme Court.
Yeah. Yes. Document number 34619.
So same order. Just take that. Counsel for the petitioner points out that in a judgment dated
Year 2022 Supreme Court 4558
in Union of India versus Ganapati Dealcom Private Limited, AIR 2022 SC 4558, it has been held that
Para 18E, my lord, Para 18(1)E.
That the proceedings against the company in liquidation, right?
Sorry, my lord.
Proceedings against this, you have the judgment, sir.
Yes, my lord.
My Lord, review pending.
No, I'm just going to note that, sir. Proceedings against a company under the resolution process in terms of insolvency and bankruptcy court cannot continue.
Para 18(1)E. Para 18(1)E. I have given that relevant paragraph. Relevant paragraph I have opened the book.
Where have you given it?
Para 18(1)E.
All right.
I have marked.
Right. It has been specifically held that the concerned authorities cannot initiate or continue criminal prosecution or confiscation proceedings for transactions entered into prior to coming into force of the IBC, that is 25th October 2016. Paragraph. Counsel for the Unit of India informs the court that a review petition, bracket diary number 34619 of 2022, unquote, against the above judgment, seeking review of the above judgment, has been filed in the Supreme Court of India on 31st October 2022 and therefore prays for an adjournment. Paragraph. At his request, list on 13th April.
13th April.
Number 80.
Interim order to continue in all these cases.
All right. Interim order to continue.
Item number 80.
Short adjournment.
Sorry.
Mention 80 and 82.
Already taken up.
Adjourn to 25th.
Yes.
Adjourn to 25th April. Item 81.
Item 81 more 4 weeks time.
I see. Reply to file within 8 weeks to the next date. Based on 13th April. Is there an interim order?
My lord, there's an interim order.
Okay, interim order to continue.
Item number 83.
Here at 82, my lords, is the matter your lordship will recollect, where certified copies were not given to me and I was issued a show cause notice. The certified copies, my lords, were not issued on the plea that investigation is open.
No, I think 82 we already have
adjourned to 25th April.
Sorry.
25th April, it's been adjourned.
My lords, here what is happening, the show cause notice, my lords, is time bound. So, my lords, if I may pray, my lords, sometime in January, my lords, I'm constrained to make that prayer, my lords.
Because Mr. Tushar Satpathy was unwell. He's not free today. So,
sometime in January, if your lordship, it's a small matter, my lords.
All the similar matters are coming up on that day. That's why. There are other similar matters.
Similar to this, my lords, the issue, my lords, is that certified copies are not being given.
Okay, all right. You just change the date in this alone. List on 11 January.
Very well.
All right.
Grateful.
All right.
Item number 83.
It's Mr. Patra's only.
83.
Power.
Ah.
My lord, sir. What 85? Yes, yes.
Same order. Make the corrections. All right.
For hearing item 84.
May I please? The questions of law were admitted by your lordships on 18/5/2022, my lords. And the questions of law which were admitted, my lord, is lordship would kindly turn to page 9, my lords. Questions number small Roman 2, Roman 3, and Roman 4, my lord.
That's it. Depreciation.
Depreciation, my lord. My claim for depreciation. My claim for depreciation was 15%. 30%, and it was reduced to 15%. And that's how the
saying that you own your vehicles only if you're hiring, then you can have higher depreciation.
My humble contention, my lord, is the petitioner, my lord, she got a
1 minute. Who's for the department? Is Mr. Mahapatra or Mr. Satpathy? Here it says Mr. Mahapatra.
Jharsuguda, my lord, I think Mr. Mahapatra would be appearing.
He's not here. Should we wait for him or we'll have it on another day?
As your lordship pleases.
All right. None appears for the department. In the interest of justice, list on 20th April. 20 April.
20
April.
Item number 85.
No, 85, my lord. My preliminary objection is the read petition is not maintainable in guise of PIL because in a read petition, a sale deed which a registered sale deed
is ought to be challenged.
How it will be, my lord, set aside in the read application?
My submission is one week on any day in this coming week.
What?
The case may be hard.
No. If you're challenging a sale deed, you file a civil suit, sir.
Yes.
No, my lord, that is not the case, my lord. It is under section 19(5) of the Odisha Hindu Religious Amendment. It is not under civil suit, my lord.
No. I think her point is that you're challenging a execution of 64 sale deeds.
No, my lord. That is consequentially, my lord, by virtue of the order of a revisional authority, my lord. My lord, page 21. Page 21 of the counter repeat, page 21 of the petition.
You're one of the purchasers, is it?
Yes. He is the vendor.
I have invested 50 lakhs rupees. It is a banner in an auction purchase.
My little submission is that
deal with the property, my lord.
Yes, that is true. My lord, my little submission is that my lord, the counter affidavit which has been filed by the OP number 8, my lord, the respective para, page 24. Page 24 is the valuation. My lord, the present valuation is.
No, whatever the ground. I think what she's trying to argue is you may have several grounds on which you want to challenge the sale deed. She's not disputing that your right to challenge. She says you do it in appropriate proceedings.
No, my lord, I have challenged the order of revisional authority, my lord. I have not challenged the sale deed. 68 sale deed have been executed.
Even then, sir, I don't know whether a PIL will lie against an order of by the
revisional authority, because any person, my lord, I will satisfy, my lord, how I am affected party in this case. Because, my lord, the revisional authority, the commissioner's order is, my lord, the commissioner order is page 16. My lord. Yes. Page 16 is the order. My lord, when the London Commissioner under section 19 has come to the conclusion that the benchmark valuation, relevant page is page 21, my lord. Page 21. The relevant page is that when the benchmark valuation was 1,84,800, he fixed the value of the land of 14 lakhs per acre. 14 lakhs per acre. My lord, what happened? That immediately thereafter, the revisional authority has reduced the value to twice the benchmark value. That is 3,86,000.
That is the crux of the matter, not the sale deed. Only on that ground when the matter
And that is also, my lord, the fact has not been.
Here the question is,
placed before your lord.
here, my lord, the question is how and when he is justified to reduce the rate when the commissioner on the
No. Did the commissioner have material? Because what seems to be suggested in the reply,
yes,
come to para 7 of the reply of the government.
My lord, I have seen that.
See, they said there was no material. He simply fixed it at 14 lakhs without any material.
My lord, it is now, my lord, I am coming to the conclusion because my lord has come to the correct conclusion. My lord, the value of the land at present is 2 crore somewhere.
No, that is, see, land prices keep going up.
No, my lord, it is within 1 year. My lord,
no. This is 2017.
My lord, the 19 order is 19. Order is revisional authorities, order is 19. My lord,
And the sale deed was executed in 19.
My page 24, my lord. Yes, my lord.
How? The sale deed.
Yes, my lord. The page 24. Page 24 of the counter affidavit is very vital. That is the map. It is just adjacent to the national highway.
No. One thing, sir, we can't be determining the actual value. There will be experts for this. Government fixes the rates. Sir, I don't know, in cities it's called circle rate. I don't know what is called here.
Benchmark value.
Benchmark value.
Yes.
Correct.
Collector fixes it. Collector fixes it.
Collector fixes the rent. Collector fixes the rent. But the law and commissioner.
No. So the commissioner went far beyond what the collector had fixed.
No. Collector, it is a benchmark valuation is revised after every year. Benchmark valuation is the purchase price of that area.
Correct.
Because my lord knows that the land is sold at the reduced rate.
Right.
When the value is higher, the rate is
so that's why I'm asking you to read para 7. Benchmark value was 1,84,000.
Yes, my lord.
And this man fixed it at 14 lakhs.
Yes, my lord. Yes, my lord. That is true. But now it is
everything is, I can't say it is true, sir. You have to explain.
Everything that
how did 1.84 lakhs become 14 lakhs?
My lord, can I submit to the page number 8 of the counter affidavit, my lord?
Yes. But you read para 7 first.
Yes, I have sent. Page 8.
No, para 7 you first read.
Para 7.
Yes.
So
yes, my lord.
Near the road will be more, inside will be less. In the same area, depending on, absolutely.
No, those areas adjacent to national level, it is.
No, you read that para 7.
Yes, my lord, I am holding that. In reply to averments made in paragraph 3.5 of the writ application, it is humbly submitted that as reflected in the judgment dated 27 December 2017 of the Commissioner of Endowment, the benchmark valuation of the land received from the sub-register Digopondi in the locality for the year 2016 and 17 was 1,84,000. Yes.
Read on, sir.
Per acre. But the EC has fixed the offset price of 14 lakhs.
Per acre.
Per acre, my lord.
Read on.
On a presumption that the actual market price of the cash land would have been much more than the price reflected in the benchmark valuation. There are no material before the commissioner to fix the offset price. No person would have come forward to purchase the debt land at the offset price fixed by the commissioner, thereby defeating the purpose of 19(1). My lord, I may kindly invite my lord's attention to the paragraph that was section 19. My lord.
Everything can be gone into
yes,
suit, my lord.
I am submitting that.
Everything can.
It will not come under suit. It will not come under suit. It will be the decision of the revisional authority.
No, what should be the correct value? How can it be determined like this, sir?
My lord, the revisional commissioner and revisional authority has no power to reduce. No power.
The other way around, sir. First, how do you have power to increase? That's the first you have to answer.
My lord, I 19 plus 5. 19.5. 19.5.
Hmm.
19.5, my lord. In any case, where the appeal has not been made to the state government, it appears to the state government that the alienation is not necessary or beneficial to the institution, or that the consideration fixed in respect of the transfer by exchange, sale, mortgage, or lease for a term exceeding 5 years is inadequate. The amount which has been reduced, is it adequate? Inadequate. Only in case of inadequate, the power is revisional authority to reduce. Not, yes. But he cannot, he has no power to reduce. It is not inadequate. The word inadequate is sufficient.
You're mistaking too many things, sir. specifically on the power to fix a higher benchmark value. This has nothing to do with that. This simply says that the consideration so and so is inadequate.
Yeah, no, right. Only the date
He can't fix the benchmark value, sir. He can say this is inadequate and send it back for redetermination.
Benchmark value.
So where did he get 14 lakhs?
No, benchmark
This will not help him to fix it at 14 lakhs.
My lord, benchmark value is fixed.
Yes, price. Correct. 10%, 5% will mark up. Correct.
Benchmark value is fixed by the collector.
So that exercise only the collector can do. This power is only to determine if the overall consideration in a sale deed is inadequate. Suppose you present, let's say, for 100 yards of plot.
Yes.
You present a sale deed for 3 crores sale consideration. This man feels 3 crores is too less. He can't determine the value again, sir. He can't say, no, now calculate the value at something else. He can only send it back, saying that let the collector again examine to find out if this benchmark value is the correct benchmark value.
My lord, my whole submission is that the matter may be remanded to the appellate authority, revisional authority.
No. In a PIL, see, this is the difficulty in a PIL, sir. See, we must have an affected party, correct?
Yes.
One party can't be affected by some 64 sale deeds in respect of so many people.
My lord, all the decisions, my lord, have passed only in the PIL, my lord. In the it is only in the PIL, my lord. All the deities have been protected by my lord's order because it is the affecting the interest of the deity, my lord.
Actually, the Commissioner of Endowments is supposed to be looking into these matters, right?
May be remanded to that, my lord. I have no maybe.
Now the commissioner also cannot, my lord, set aside the sale deed.
Order is only revisable by the. The endowment commissioner fixed it at 14 lakhs.
Yes.
What is against the endowment commissioner's order?
No.
Who's anyone appearing for the endowment? What is your stand in this matter?
Matter, my lord. See, Mr. Naidu is doing this matter. So that matter will
not ready.
Yes, ma'am.
Because
your instruction is taken adjournment.
My anxiety is.
Mr. Savantra, no, against the endowment commissioner's order, the remedy is a writ petition.
No. Appeal to the state government.
Appeal to state government.
Yes.
1905.
Yes.
1905 very clearly mentioned that. Appeal
Mr. Naidu is here.
1905.
It is before my lord.
And 1905 has been adjusted.
Oh.
No, 1905 not has been adjusted. Not has been adjusted.
And challenging the order of the state government, you are saying that.
No, not has been adjusted. Because the power is the division. I have filed directly before this honorable court because there is the deity's property is going to be sold in the reduced rate. That is only the discretion of the my lords. My lords, the property of the deity should be protected.
Petition, your lordship will set aside the sale deed.
No, I have not prayed for sale deed. I have said the revisional power.
To set aside the sale deed.
That is
and I have annexed
the revisional power of the revisional authority to reduce the benchmark value.
And the sale deed only can, my lord, set aside as per the provisions of specific relief act, my lord. Shoot.
No. What you annexed is annexure 1 is only the endowment commissioner order.
No, that is that after my lord, the revisional order, my lord.
Where is that?
That is
page 28, ma'am. Page 28.
Everything has been adjusted. They are challenging. Your lordship will kindly turn to
the order dated
page 28, my lord. Order 11019. 11019. After, my lord, the appeal was filed.
Appeal? Where is that appeal?
Appeal was filed before the government.
It is
the government
it is not
considering the benchmark valuation given by the collector have fixed the rate, my lord. It is 1 lakh somewhat. The offset price was fixed by the government at 3 lakhs. And in auction, my lord, I have purchased more than 10 lakhs per acre.
Modified the order of EC commissioner, endowment commissioner by fixing offset price double the benchmark valuation only.
And my lord, in the auction, my lord, I have purchased more than 10 lakhs. Though the offset price is 3 lakh some odd.
So it's more than double.
Yeah, more than triple, my lord. 3 lakhs some odd. I have purchased more than 10 lakhs per acre.
My lord, he has purchased the land with rupees 50 lakhs, where the proper valuation is coming 84 lakhs, my lord.
5 acres land.
That proper valuation, how did you determine?
My lord, the present valuation, my lord, I am reading, my lord, page 8. Page 8, my lord. Page 8, no, page
No, valuation of which year?
My lord, the present valuation of the which yes, my lord. This is also indicated in that case. It is in the year of 19. The sale deed was executed in the 19. But when the sale deed was executed.
Okay, 1 minute. Let's get what is the stand of the endorsement commissioner here?
Your Lordships, here is a case wherein the benchmark valuation and the market value is basically in question. The land always has to be sold at the highest possible price.
Yes, ma'am.
So that the DT can, that is the only stand which I can put forth.
No, but if you unreasonably see the benchmark value is 1.84 lakhs per acre.
Yes, sir.
And the endowment commissioner said it should be 14 lakhs per acre. On what basis did he do that? That's not clear.
Your Lordships, the point is always the benchmark is always the lowest price. The market, the surrounding says when the survey reports come wrong, the sale deeds of that particular area.
Where is that material? See, that is what is being pointed out. There must be material in the form of sale deeds to suggest the market value, as in this case, has become 7 times the benchmark value. Was there any sale deed like that?
Yes, Lordship, that is all there on record. Also.
Where? Which sale deed?
He has produced, in fact. The petitioner has produced them.
What? No. He has not produced anything. He's only 2 annexures to this.
My lord, page 21. Can I read, my lord?
Yes.
No, I can otherwise produce the records.
Page 20 of the my read application. Paragraph 8. Document marked as that the land are recorded in the name of deity Radha Damodar Mahaprabhu, Lakshminarayan Das, Guru Mahanto, Tirthananda Das. But this case is filed by Mahanto Gopal Charan Das. In this case, Exhibit 1 is the order passed by the then Commissioner of Endowment, wherein the Commissioner of Endowment has recognized the present petitioner as heritage trustee, successor of the deity institution. The report of the Divisional Inspector of Endowment called in this case do not disclose any such disqualification. Further, the said report declares that the case institution has about 28. The said institution, my lord, that is the case institution. The said institution has about 28 acres, 100 decimal of land. The civil lands are having 2 kilometer distance, where frequent visit is not possible on the part of petitioner as she is lady. The case land is a rain-fed land and every possibility of encroachment. The sale proceed fetch more income to the institution if it will be deposited in a nationalized bank. Thereafter, the clause paragraph 9. In this case, the benchmark valuation of the land received from the sub-register Digopondi in the locality of the year 2016, 16 and 17 has been filed by the petitioner. Even though the order was filed in the year of 17, but benchmark valuation of the 1,84,000 of 2016 that was considered. Peruse the said benchmark valuation. As per the said benchmark valuation, these land as one Bila Dofosili Act lands in the year of 2016 and 17. Their benchmark valuation is rupees 1,84,800 per acre. It is a common knowledge that the real market price is never reflected in the sale deed of the locality, basing upon which the benchmark valuation are prepared. Therefore, the actual market price in the area of the case land would be much more than the price reflected in the benchmark valuation report. It, in my considered view, considering the situation of the land.
What situation? What? How can he suddenly fix it at 14 lakhs? Where is the material for this? Where is the material? And why 18 lakhs? Why not 20 lakhs? Why not 10 lakhs?
Why not crore? 1 crore.
What is this magic number 14, sir? What is this 14? Where did he get it from?
My lord, it may be 14 or 13, but it is not.
Why should it be 14 and 13? Why can't it be 20?
But my lord,
I'm asking you, no. You tell me, sir, as a person reading the statement, where is he giving the reason why he has fixed it at 14?
Because the price of the land is going day by day.
So why can't it be 50? Why can't it be 50 then?
2 crores, my lord. It is now 2 crores.
No, so why can't this be 50?
It be. Yes.
So it can even be 100. It can even be 100. It can even be 100.
Because he has to consider.
So a commissioner can simply say 1,84,000 is too low. I am fixing it as 50.
No, that might be the incorrect.
Why is this correct and that incorrect?
But the question is,
No, you answered this question. 1,84,000 is low. Now, what should be the price instead of 1,84,000? How will you determine it?
The present valuation, my lord.
You put yourself in the shoe of this commissioner. Okay.
Yes,
you have come to the same conclusion he has come. 1,84,000 is too low. You have also come to the same conclusion. Now you're saying, now what value should I fix? First of all, should you ask that question? Itself is in doubt. Assuming you have the power to now substitute that value with some other value, what will you fix, sir? You tell me.
I will not expect that position.
Why not? You should, because you're arguing a case. See, you're defending this order, correct?
Still,
1 minute, sir. You're defending this order.
Yes, my lord.
So you have put yourself in that position of that commissioner. You have found that, like he has found 1,84,000 is too low. What value will you fix? How will you go about that exercise? She said he has gone through all sale deeds. Has he gone through all sale deeds?
Sale deeds are there.
He's not gone. She's very confidently said, no, he has gone through all sale deeds.
No, sale deed is
where has he gone through, madam?
The report, Your Lordship.
What report has he referred to?
The report of the Deputy Commissioner of Endowments has to come, the inspector.
Where is he referred to? Come to page 21. Which report has he referred to? Which report has he referred to?
No, he has not referred to this report.
Nothing. He has no material. Commissioner has no material. He's only clutching on to the fact that the commissioner fixed it at 14 and nobody to reduce it below that. He has no idea why he fixed it at 14. No, I don't even think it's the purview of the commissioner to fix, sir. Actually, our approach is wrong. If he finds the consideration inadequate, he can fix it. That's all. So you can't.
Paragraph 8 is called for the report. There is a report wherein the qualification of the petitioner, whether the land is alienable or not, and also with regard to the evaluation.
He has not called for evaluation report, madam.
Your Lordship, it comes with the report.
No. Come to paragraph 9.
Your Lordship.
This is where he's fixing the value, correct?
Yes, Your Lordship.
Where has he referred to the report?
He has not referred to the report. Then I'll be very clear.
Then what is this you're guessing yourself?
Para 8.
See, the order should read for itself.
I admit it.
In the portion where he's fixing the value at 14 lakhs,
admitted.
He's not referred to the report at all.
Admitted. I cannot go by there, but in para 8 he's referred to that's there.
And why should it be 14 lakhs? Why can't it be 100 lakhs?
Yes, fixed it, Your Lordship. I cannot justify. Whatever is there on record, I cannot.
We cannot imagine that aspect, my lord.
Why should you not? You're coming to this court, correct? You're defending. Listen, you're defending this order.
How can I arrive at the conclusion that it should be 8 lakhs, it should be 10 lakhs, it should be 1 lakh?
Then how are you defending this? You're saying it should be 14 lakhs. Your whole petition is, sir, your whole petition is it should be 14 lakhs. It should not be 1 paisa less than 14 lakhs. That is your petition. Yes. So you defend it. Tell us why it should be 14 lakhs.
My lord, the present market valuation is much more than that.
We'll simply say much more. So much more could be 100 lakhs.
This is 2 crores, my lord.
So it could be 100 lakhs.
It is more than 100 lakhs. My lord.
Okay, so per acre it's more than 100 lakhs.
Yes, my lord. This is there in the document, my lord.
Per acre more than 100 lakhs.
Yes, my lord. It is in the document, my lord. It is document, my lord. My lord, page 8, my lord. Page 8, my lord. My lord, counter affidavit of paragraph 8, my lord. Counter affidavit of OP number 8. Page 8, my lord. Page 8, my lord.
Sir, you're trying to defend an order which fixes the value at 14 lakhs per acre. Today, you're arguing before us it should be 100 lakhs per acre.
It is 2 crores, my lord. That is true. But my lord, I cannot say that it is 12 lakhs or 15 lakhs. It is the commissioner's. It is the commissioner's.
What is per acre?
My lord, I am inviting my lord's attention.
What is the
You answer, sir.
Yes, my lord. My lord, I am with document, my lord. With the document. With the document, my lord. I am not submitting outside, my lord. My lord, page 8 of their counter affidavit. Page 8. Page 8 of the counter affidavit. It is in the Odia. Benchmark value 2 crores 12 lakhs 88,000 per month in the year of 99.
Page 8.
My lord, page 8.
That is the sell deed, my lord. That is sell deed.
That is sell deed. It is sell deed is 50 lakhs. It is the benchmark value. Benchmark mulya prakare, it is 2 crores. It is benchmark mulya prakare, it is 2 crores.
So I'm sorry. It's not the benchmark value. Applying the benchmark value, the sale consideration is worked out.
Yes. This
is not the benchmark value. Don't mislead, sir. I don't know to read Odia, but I know this much.
Meaning of the
applying the benchmark value, he arrived at the sale consideration. This is not
proportionately that is worked out.
Yes.
No, proportionately, my lord.
Proportionately, it is much more, my lord. I have given 10 lakhs. It is 1,80,000 benchmark value.
What is the benchmark value?
1,80,000?
No. 1 minute. I'm just asking.
My lord.
I cannot say, Lordship. As on date, what is the value? As on date, I can say.
So you find out what even today,
Yes,
2022, what's the benchmark
I
value?
can do
Yes, my lord. That would be better.
All right. The Commissioner of Endowments will file an affidavit informing the court what, as of today, is the benchmark value of the land in question. In respect of the lands in question.
For acre, yes.
No, as of today itself. As on that date, it was 1,84,000.
Oh.
As of today, it should have, from what he's saying, it should have gone, sir, today it should go up to 4 crores an acre, according to you?
No, my lord, it is there. My lord, I do not know.
No. So whatever said in the sale deed becomes benchmark value for you.
That is what the commissioner should say.
So your understanding itself is very different, sir.
My lord.
If the sale deed is in respect of 5 acres and it says 2 crores, you will say it's 2 crores per acre.
That might be my.
Then our arithmetic all is going awry here.
And that might be my misconception, my lord.
You've not even understood the question, so you're just answering.
Yes, that might.
All right, the affidavit of the commissioner we filed at least 1 week before the next date with advance notice counsel for the 8 parties. List on 3rd April.
Your lordship may kindly modify the interim order, my lord. Because I am a bona fide purchaser, I could not deal with the property, my lord.
You just enjoy it for 3 more months.
Your lordship may kindly consider for last 1 year, more than 1 year.
No, the value, like he's saying, the value is going up and up. So you'll be happier in April from today. Yes.
Your lordship may kindly
have gone up even more in April.
Your lordship may kindly.
So instead of selling it today, you sell it then.
Your lordship may
it's in April only. It's just a matter of 3 months. It's all right. Yes.
Can be early, my lord, February.
Let it.
Your lordship may kindly take up on February, my lord.
No, it's all right.
It is more than, my lord, 1 year interim order is against me.
It's all right. 3 more months. Let's see what the collector or commissioner says. Right.
Lordship would pardon me. Lordship would pardon me. Mr. Mahapatra has come in 84. Subject to your
I'm sorry, my lord.
All right.
Your lordship can take it up as the last item. Run through the Passover.
Okay. Or if you take it up on that day only. It's all right. You just put down Mr. Mahapatra's name and simply say list on. All right.
My lord, my parents.
Yeah, we've said that.
Oh, blessed.
Supplementary list passed over matter item number 9.
The senior advocate, on the instruction of the senior advocate, Mr. Ratha, he is busy in the court number 2, my lord, in parted matter. He requested to when the last case may be taken up or tomorrow.
Maybe taken up any other date, madam.
All right. Mr. Ratha, learned counsel appearing for the respondent is in some personal difficulty today. List on.
Tomorrow, madam.
No.
Tomorrow.
12th April. Yeah.
Item number 11.
My name is.
Item 11.
Same thing. Does somebody ask for a Passover, no?
Asked for, but he's not there. The thing is that the prayer is now has become infructuous.
Correct.
Because they want to extend the prayer is for extension of time.
That's all over.
9 and 9C. We have already given
Extended.
them 1 year extension each.
Right,
17-18 and 18-19.
Right.
So it has become now.
All right. He
infructuous.
said, despite the
That-
Passover, none appears for the
My name
petitioner.
may be there.
Yeah. Counsel, Mr. So-and-so appearing for the Union of India informs the court that the prayers have been rendered infructuous. The petition is accordingly dismissed.
My appearance may be.
Weekly list for hearing. Item number 2.
Question is at
Item number 5.
2. Item number 2.
No, the respondent is not here today.
Yes, yes.
Item number 5.
May I please your lordship?
My Lord, appearing for respondent, my Lord.
All right.
My Lord, accepting the first item, other items, I think, my Lord, is below the monetary limit.
Oh,
My lord,
below the monetary limit, except one.
my lord, it's a batch of petition. If your lordship will come to the facts, it's all these appeals arising out of a common order.
All right.
And out of a particular series event. My lord.
All right.
So
circular of the board is there.
exceeding around 4 crores. My lord.
My Lord, circular of the board is that each appeal arising out of a common order will be considered separately for the monetary limit. My friend is there, my Lord, circular of the board, 26 December 2014. December 2014, my Lord, para 2 may be seen. Last 3-4 lines, my Lord. The second issue relates to. The second issue, para 2, second was last 3-4 lines. The second issue relates to applicability of the threshold limit in various situations, mostly where the appellate authority disposes of more than one appeal in a common order, which is sought to be challenged. Such order generally involve cases of more than one parties, some of which fall below the monetary limit fixed for filing appeal in the forum of appeal. The my Lord straight away come to para 4. The instructions mentioned above use the word case. However, the same was not defined. The term case needs to be interpreted in the context of national litigation policy, which aims at the reduction of litigation in respect of a complete composite order which disposes of more than one appeal, SCN, and the department contemplates filing appeal. Every appeal would be a case and should be subjected to the threshold limit prescribed. If the tribunal passes one composite order disposing of more than one appeal filed before it, and if the department being aggrieved is required to file more than one appeal against the said tribunal order, then each appeal shall be subjected to monetary limit prescribed.
This is correct, sir.
My lord, in this case, my lord, here the partners and directors are the same of the same company.
But it makes no difference, sir. One composite order for several years.
My lord. My lord, if your lordship would come to the notification clause 4, my lord, the first page clause
This
4.
is the clarification of that only. This clarification is 26 December 2014.
My lord.
Whereas the notification is
No, the notification is 2019, my lord.
right.
My lord.
The same. It's only the limits that have changed, sir.
Limits, but in clause 4, your lordship will come.
Yeah.
It may be noted that issues involving substantial question of law are described in para 1.3 of the instruction dated 17/8/2011 from such and such number would be contested irrespective of the prescribed monetary limit. Correct. Here the question.
So you'll have to look at instruction of 17/8/2011.
That I'll get it.
Correct. Where is that instruction of 17/8/2011?
That right now I don't have.
That is there in the bench, my Lord.
Yes.
Para 2 may be seen. In the bench, it is there, my Lord.
In the bunch?
My Lord, your Lordship have got 2 circulars or more than that, my Lord?
2.
Only 2, my Lord. Then it is not there with your Lordship. If your Lordship will permit me, I will read it from the copy I have with me.
Yes.
May I read, my Lord?
Yes, yes.
What I pay, my lord?
For ascertaining whether a matter would be covered within or without the ever mentioned limit, the determinative element would be duty tax under dispute. To illustrate, if further, it illustrate further, if in a case involving duty of 5 lakhs or below with equal penalty and interest, as the case may be, no appeal shall be filed in the tribunal. Similarly, no appeal shall be filed in the High Court if the duty involved does not exceed 10 lakh. At that point of time, the limit was less, my lord, with or without penalty and interest. Further, the commissariat shall also send proposal to the board of filing civil appeal or SLP in the Supreme Court in the case involving.
Say anyway, let us hear the appeal itself. Anyway, one appeal has to be heard. Let us hear it now. Let's not get bogged down. If you are not on merits in that first appeal itself, then nothing else survives. The same questions have been framed in all appeals. Correct?
2 appeals, same question.
No, my lord. Only in 2 appeals.
Another 3 appeals, only notice has been issued.
So let's start with the merits.
Much obliged. My lord, on 11 December 2017, the Honorable Court has framed 3 questions of law. Whether in the facts and circumstances of the case, when the investigating officer have never taken the printout of the Sundarlal ledger account from the computer, rather seized the said document from the residential premises of the accountant of the respondent. Under such admitted fact, the tribunal is correct in observing that the said document cannot be used as an evidence for not satisfying the condition laid down in section 36 capital B2 of the Central Excise Act 1944.
Carry on.
Second, whether the present facts and circumstances of the case, the tribunal is correct in applying the observation of the Honorable Supreme Court made in the case of Anwar PB to the present case, without considering the fact and circumstances on which the Honorable Apex Court has delivered the said judgment.
That is 65B.
That is 65B.
That is mandatory, sir.
That is 65B mandatory, my lord.
Yeah.
But
now Anwar has been further explained in subsequent judgment of the Supreme Court.
My lord. But yes, here the case that we have not taken the printout, my lord. The first
you don't need to take a printout. The whole problem is how do you prove the document?
My lord. That has been. I will come to the facts also. That document has been proved in while tallying the bank accounts, my lord.
Right.
It has been tallied with the bank account of the respondent.
Right.
Secondly, their director has also accepted that that document belongs to. It is nothing but the supply made by the.
The director admitting is neither here nor there, sir.
My lord.
The director himself is facing the proceedings, correct?
My lord.
His admission is to no avail. You are the department. My lord. You've seized an electronic document.
No, it's not an electronic document, my lord. It's just a paper printout, my lord.
Worse still, sir, if you look at the definition under the IT Act, a printout from a computer is also an electronic document. Please see the definition.
My lord, the definition of electronic, it has been prescribed under section 36(2) itself.
All right, let's see that.
My lord, a compilation I have given to my friend. In the compilation, statute is there, my lord. 65B, 36B, all are there, my lord.
Your lordship, kindly turn to section 36B, my lord.
In the compilation, my lord, page 2 minutes.
Just let me submit.
Yes.
May I place it?
Yes.
Admissibility of microfilms, facsimile copies of documents, and computer printouts as documents and evidence.
So computer printouts.
My lord. Then subsection 2, your lordship kindly come.
Yes.
The condition referred to in subsection 1 in respect of a computer printout shall be the following.
Correct.
Namely, the computer printout containing the statement was produced by the computer.
Correct.
During the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried on over that period by the person having lawful control over
the entire conditions are the same as 65B(4) of the Evidence Act.
My lord.
So you have to file an affidavit, but the affidavit has to be by a person who actually was in charge of that computer and can vouch for the fact that the computer was working properly.
Here, my lord. I should take your lordship to the facts of the case.
All right.
There was a seizure
Right.
Seize happened in the two factory premises.
Right.
And the residence of the accountant.
Correct.
These printout.
Yes.
These documents has been seized from the resident of the account. This is a piece of paper containing 3 pages, my lord.
Right. But it came from the computer.
It came from the computer.
Correct. So it's a computer printout.
It is my lord, kindly see. What a computer printout has been made.
Yes.
That has been corroborated with the bank account as well as the statement of the director.
No, you're straight away going. First of all, we are on the admissibility of this computer printout. Only then you can start comparing.
My lord.
How do you prove it to be an admissible document is the first question. Otherwise, somebody can just sit before a computer, type out whatever and print it out and say it's a computer printout. That's not what this means, sir.
Here the computer has not been seized.
So that's your difficulty then. Once you are relying on a computer printout, this section tells you how you can rely on it.
My lord.
You can rely on it only if it satisfies these conditions. Somebody should tell you that this computer printout came out from a computer which was in a proper working condition. The person has watched that computer being worked in a proper condition. He has to vouch for the correctness of that machine, that it is in a proper working condition.
That's true.
Without that, you can't rely on this printout.
If we read this subsection as a whole, my lord.
Yes.
What I understood, my lord.
Yes.
If during the seizure,
yes,
I'm taking some printouts.
Yes.
Then we have to seize that computer.
Need not.
Which where
you may or may not seize a computer. See, the point is, it's a product of a computer.
My lord.
If you do not seize the computer also, you still have to satisfy these requirements.
My lord.
For instance, during the said period, there was regular supply to the computer in the ordinary course of the said activities, information of the kind contained in the statement. For instance, you buy a new computer. The only document you are typing is this one page.
My lord.
It will not help you prove it. Because regularly data would have to be fed into the computer. It is regularly used in the course of business. So somebody has to vouch for it. Only a person in charge of that machine can give that certificate.
My lord, so suppose in this case, my lord, this has not been done in his personal computer or in the office of the computers.
Correct.
It may not have been done. It may not have been done in some cafe or somewhere where any computer is available.
Yes.
But in that case, it is very difficult for the...
So the difficulty is one part. What the section requires is another.
My lord. But so far as what I understood from the reading of the subsection 2, there where we took the printout, which called as the computer printouts. We took the printouts and we'll produce that as evidence. Then only we have to follow these procedures.
No, anyone, sir. For instance, an inspector goes into a house. He seizes laptops. He seizes a PC.
My lord.
He will have to then, because it is in his custody, in his possession.
My lord.
Right?
My lord.
If he's then going to print out something from that, he'll have to then certify.
Then here there is
no. If not, then his task becomes even more difficult. Then he still has to get a certificate from the person who was in charge. See, this requirement will not get diluted. Which is why policemen seize the entire thing.
My lord.
Because they then become in charge.
My lord.
Then they can vouch, listen, this computer was working. I have taken a printout from this very computer. If they don't do it, they'll be dependent on the person from whose premises they seized it. For that person to give a certificate. Why is he going to give a certificate? If he's an accused, he will never give a certificate.
In this case also, I must admit, he has denied.
Naturally.
He has denied, my lord.
Naturally. So this puts a very high threshold. This is the problem. This is the problem in this kind of a seizure, that you don't take precautions. You don't take precautions, then you are in trouble.
That's true, that's true. But so far,
don't compel then a court to accept it.
No, I'm not compelling the court.
No.
What I understand,
I'm just generally saying. See, the whole thing is you have to satisfy some court that this is properly gathered evidence. This is about properly gathering evidence. Unless you satisfy the court, why will the court believe it?
My lord, what has happened, my lord, in this case, if I read the section 2, subsection 2, clause A, B, C, D as a whole, your lordship will see the intention of the legislature. If I am taking out any printout of some documents and I am using as an evidence.
See, you may be a police officer. You may be, in this case, what? A customs official.
My lord, DGC.
Customs official. Or intelligence.
Intelligence.
Customs intelligence.
Central Excise Intelligence.
No, merely because the section doesn't say if you're a police officer, if you're a customs intelligence, the section will not apply.
No.
You're trying to convince me, see, why would I as a customs official not produce a document which is...
No, my lord. Here the document, I have not taken out the printout of the document, my lord.
Okay, the printer is lying next to the computer. All right.
No, my lord. Just a piece of paper which has been seized.
No. You yourself say it's a computer printout.
Computer print that has been named as computer printout, but it is a piece of paper. It is a statement, my lord.
Then it's even worse, sir. Then the question is, where did you get it from? Then this whole 36B and all will not apply. Once you admit it's a computer printout, all this will get attracted.
It's named as computer print. It's a piece of paper having the statement, my lord.
Right.
It is a piece.
Why would we believe? Why should we believe it?
If you're
where did it come from? Is the question. See, now you're arguing as a matter of desperation that it's just a piece of paper.
No.
The whole question was framed because everybody went knowing that this is a computer printout.
It is named as computer printout.
Come on.
If your lordship will come to the question of law 1 again, I'll just read it out, man.
Yeah. And after this,
I'll just read out.
Part of the bench. Just see this.
Whether the facts and circumstances of the case, when the investigating officer have never taken the printout of Sundarlal ledger account from the computer, rather seized the said document from the residential premises of the accountant of the respondent. Under such admitted fact, the tribunal is correct in observing that the said document cannot be used as an evidence for not satisfying the condition laid down in section 36B2. It is a document, my lord. It is. I have not taken a printout from any computer. It is a seized document from the accountant of the respondent.
Let's read the narration. Let's see from the tribunal's order. We'll get to know what it is. Come.
On page 31, my lord. Last para, my lord. Bottom.
No. The facts of the case. Your lordship, kindly come to the facts of the case.
Yes.
Page 21, my lord.
Right.
The first table, your lordship will see. This is the total demand, and it is all correlated, my lord. The second paragraph. Brief of the facts that the case are appellant Messrs. Bajrang Steel and Alloys Private Limited. Here it is the OTAPL number 17, my lord. Is the manufacturer of MS Ignots falling under Central Excise Tariff heading 7206.9 of the Central Excise Tariff Act. Appellant Messrs. Shivam Steel Corporation is the present respondent. Is the manufacturer of MS bar, MS plugs, pipes, angles, channels, profiles, etc. falling under Chapter 72 and 73 of the Central Excise Tariff Act. Sri Ajay Bansal, respondent, it is the OTAPL number 16, my lord, is the director, appellant number 2, and is also a partner of the appellant number 1, which is respondent number OTAPL number 15, my lord. Sri Rajendra Agrawal is also a partner of the appellant number 1. On 11/8/2000, simultaneous searches were carried out by the officers of Director General of Central Excise Intelligence in the premises of appellant number 1, 2, and some residential premises. Another premises of Sri Sanatan Maiti was also searched on 11/8/2006. This Sanatan Maiti's premises, this document has been recovered. Who was the accountant of the appellant number 1? Officers of DGC recovered a private diary and certain documents from the residential premises of Sri Sanatan Maiti. Sri Maiti, in his statement dated 11/8/2006, 4/9/2006, and 5/9/2006, inter alia stated that paper recovered from his residence premises, document number 11 and such as reveals purchase of ignots, production of rods, sales of rods, production of scraps, purchase and consumption of coal, and furnace oil by the appellant number 1 for the month of February, March, and April 2004. He also confirmed these documents also revealed sale receipts of rods from various parties, and that these documents are raw working sheets. Statements of Sri Ajay Bansal were recorded on 11/8/2006, 6/9/2006, and 29/6/2007 as partner of Messrs. Shivam Steel Corporation. He was also shown the document recovered from the residence of Sanatan Maiti when he confirmed in his statement dated 11/8/2006 that as per this document and statement of Sri Sanatan Maiti, ignats were shown to be purchased from the Sundarlal, but actually the goods were purchased from appellant number 2. So, Sri Ajay Bansal also stated that he was not aware as to why the said documents named Sundarlal was mentioned. He also agreed to pay the central excise duty on the parallel invoices quantity cleared by appellant number 2 as a clearance meant mistake, and that payment of sale from the customer are received mainly through checks, DD, and rarely through cash. By another statement dated 26/9/2007, appellant Sri Ajay Bansal agreed that they are selling re-roll products to one Messrs. Bajrangbali Steel Private Limited, and that in some cases finished goods were cleared without payment of central excise duty. Under this statement dated 26/9/2007, he expressed his inability to comment on the documents recovered from the residential premises of Sri Sanatan, Sri Amit Kumar Agrawal and Sri Premchand Agrawal, director. Bajrang Steel.
No, let's cut all this. Okay,
my lord.
Come to page 60. Annexure 6.
Page 60.
Annexure 6.
Yes, ma'am.
This is the document.
My lord. This is the document. My lord.
Are you suggesting that this is not a computer printout?
It is.
This is the problem. You see, we can talk in the air a lot of things.
My lord, it is a document which has been.
This nobody is going to be. Nobody can accept your statement that this is either handwritten or this is typed.
My lord, I'm not denying it has.
It has come from a computer.
Printout has been taken from a computer. My lord.
So I'm not denying that. So no point in arguing that this document is not a computer printout. Let's now get past that. There's no point in arguing this is not a computer printout. It is nothing but a computer printout.
It is a computer printout named as a computer.
All our offices, everything stopped using computer typewriters some 20 years ago.
No. It is a printout from the computer.
So then we keep this entire argument is unnecessary. That it's not a computer printout. It is a computer printout.
It is a computer printout.
Next question number 2. If it is a computer printout, 36B applies.
Applies or not?
So as simple as that. Now let's get down to the argument.
My lord. 36B2 is applicable to those documents where I used is as evidence.
No, you or somebody else. See, let's look at the scenario. If you go, you seize the computer, you bring it to your office and then print out something from that computer, you will be required to give the certificate.
My lord.
Right?
Right.
If you go, you only take the printout and come away, the burden of proving this is not dispensed with. It just makes it difficult for you because now the certificate you can't give. Only the person who was in charge of that computer will have to give.
My lord.
If you don't produce that, then you're back to square one. You have no means of proving it.
Here the documents, the documents under Annexure 6 was recovered directly from the residence of the.
All the more, sir, which is why a lot of training took place. I don't know whether you're aware. Manuals were printed out for all these raiding parties. I've seen those income tax manuals, central excise manuals. They were prepared to tell the teams how they should go into a premises, how they should seize. If they simply saw computer printouts, they wouldn't simply seize the printouts. They'll bring the whole machine. The machine may contain something else. The printout may be something else. So they will never take the risk of just bringing those sheets of paper. Correct. So they would cross-check with that. They've done nothing of that sort. They've just simply gone and picked up papers. The whole problem.
It is a piece of paper, sir.
It is not longer. See, this is the whole problem. You thought it is a piece of paper. It's actually a computer printout.
It has been taken out from a computer.
Yes,
So
which is what.
Who will vouch save that? Who will vouch for that? That printout copy has come out from that computer.
No, it is not. It has been only seized from the residential premises of the without.
That's right. No. So somebody will have to say from which computer it came.
And that computer satisfies all these requirements.
Source. We are asking about source of that paper.
That is not mentioned.
Then how is it satisfying this requirement?
That has not been mentioned. That has not been mentioned.
So it's plain.
That has not been mentioned.
The source.
You can't.
How can you prove that? This is the
So, which is why in our call detail records, we see mobile phones of so many people, right? To prove the call detail record, they call the service provider's man. The Airtel man comes to the court and he gives evidence because he's the only one who can give the certificate. Nobody else can give it. In respect of a mobile tower, which police inspector can give a certificate? He cannot. The person in charge of the operation of the mobile tower has to give it.
My lord. Recently in this WhatsApp case, your lordship also knows the Supreme Court decision that so many evidence, electronic evidence can be taken up. But here, my case is that I have not taken the printout. I don't know the source from where.
All the more then. This is why they're not believing you. This is the problem. You hit the nail on the head. Since you've simply picked up the paper, you have no idea which computer it came from. You have no idea what the state of the computer was.
Only that piece of paper has been tallied.
It's not simply a piece of paper, sir. That's the problem.
The statement, the computer printout statement has been tallied with the bank account.
So which is why the title of the section itself says admissibility of microfilms, facsimile copies and computer printouts.
My lord.
That's it.
My lord, may I submit 2 lines, my lord? My lord, may I submit 2 lines, my lord?
language is this.
At your risk, sir. We thought of dismissing the appeals, but if you say something, we might change our mind.
What your lordship has said, judgment of Supreme Court in the case of Arjun Pandit Rao is there in the compilation, my lord.
Yes.
But Supreme Court has already said.
Yes.
Earlier there was judgment Supreme Court in Safi Muhammad, in which Supreme Court
Anwar, PV Anwar.
Yes, my lord. There are 2 judgments. Larger bench is Anwar PV and Safi Muhammad division bench.
Right.
Division bench said certificate is not required, which is overruled in the Arjun Pandit Rao.
Correct.
Pandit Rao has overruled Safi Muhammad.
All right.
So even if a document is seized without the device, certificate is required.
All right. So the appeals are dismissed. We'll pass the orders. So this, we don't have to go into the monetary limit, sir.
My lord.
All right. Do you have the manuals? I hope they have prepared.
Yes, I do have.
You know, on a lighter note, I don't know if you're aware, in the early days of computer, when the police inspectors went to seize materials, they didn't realize that the computer actually is the central processing unit. They would simply seize the monitor without because they didn't know that is the computer, this is only the monitor. So many years later, when it came to proving in court, only the monitor will be there, no computer. All right.
Obliged.
Okay.
Obliged, my lord.
All right.
Weekly list item number 6.
Item number 6 is the matter that constitutional validity of section 2J.
Yes.
6th February, your lordship, identical matters have been fixed.
All right. 6th February, right?
Your lordship.
All right. List on 6th February. Along with, you just give us the number.
Your lordship, I'm just giving the number.
Your lordship, it's
HPC Limited.
HPC Limited 21892
of
2012.
2012. All right.
Much obliged, your lordship.
All right.
Item number 7.
Item 7, my lord, on behalf of Mr. Mahapatra, my lord, taken off after vacation or next week, my lord. My lord, is suffering from severe
All right. It will stay on board, sir. It will stay on board.
Item number 8.
May I please? Lordship may kindly turn to order dated 9/4/2018, Lords. There the questions of law has been framed, Lords. And after admit, they say that the issue raised in the present revision is as to whether in the facts and circumstances of the case, the goods sold to the customers would find place under entry 50 of part 1 or as unscheduled goods as claimed by the petitioners or under entry 26 of part 2 found
so
by
the
the
demand
tribunal.
is 22,000.
It's a small car parts dealer. My lord. What has happened in this case, my lord?
22,000 you want to pursue.
It's a small car dealer.
Still.
Whatever your lordship pleases, my lord, but
As long as it's a car dealer, he can afford 22,000.
Question is, now the car air conditioners has been equated with an air conditioner which is used at home.
Okay.
So
already 14,000 deposited units.
I know.
If your lordship would restrict it to 14,000, then
That's a good try. All right. The tax amount being insignificant, the court is not persuaded to interfere. However, the questioner will have let open petition some other appropriate case. The petition is disposed of.
Obliged.
Item number 9.
Item number 9 may stay on board, your lordship. Mr. Pradhan was ready, your lordship. Stay on board, I will do next.
One part is over.
9,
Your lordship, fine.
Main part is over.
Only water part is there.
And status.
Disposed of. It has to be the same weight. All right, stay on board. All right.
Your lordship.
But there's a large batch. This is 6 matters.
Your lordship.
Only to decide whether
That water.
unjust enrichment is there.
Your lordship. Your lordship.
That kinless water is gone.
Your lordship. Only that.
Are
I
you
had,
still-
I had argued all these cases before tribunal and drafted by my lord.
It's a transferred brief, my lord. I'm filing fresh wakalatnama that may be taken on record. I have no
Alright.
objection to it.
All right. The wakalatnama of the counsel for the respondent is taken on record. All right.
Item number 10.
Question of law, my lord, at page 6, capital paragraph C, my lord. Whether the tribunal is correct in holding that tractor trolley comes under motor vehicle as defined under section 2H of the OET Act, particularly when tractor is excluded from motor vehicle with effect from 1/2004. My lord, next question is capital E. Whether entry tax is leviable on tractor trolley undisputedly when the same does not find place in any of the schedules appended to the OET Act, unless and until this is find place in the schedule, no taxes, no entry tax is leviable, my lord. My lord, your lordship may kindly see
Entry tax. Oh, so you succeeded in the first appellate authority in the
Yes, my
state
lord, my
petition
lord.
appeal.
Tribunal reversed it without assigning any valid reason. Your lordship may kindly see definition 2 small h. May I read, my lord?
Yes.
Motor vehicle means a motor vehicle as defined in clause 28 of section 2 of Motor Vehicles Act 1988, excluding any tractor, earth mover, excavator, bulldozer, or road roller. Your lordship may kindly see my submission at paragraph B, my lord, page 7. For that, section 2H of the OET Act defines motor vehicles means a motor vehicle as defined in clause 28 of section 2 of the Motor Vehicle, excluding the tractor, earth mover, excavator, bulldozer, road roller. Where perusal of the aforesaid definition goes with heavy sound that tractor does not come under motor vehicle, and as such the trolley attached with the tractor cannot by any stretch of imagination comes under the definition of motor vehicle. Therefore, the order of the tribunal under Annexure 3 is not maintainable. My lord,
So what did you got trolleys, is it?
Yes, my lord, trolley.
Not the tractor, only the trolley you got.
Only the trolley, my lord.
So you say if tractor itself is excluded, more so trolley.
Yes, fine.
Although the word trolley is not used here.
My lord, trolley has no use except the tractor.
And trolley is not excluded here. See, trolley is not excluded from this.
No, my
Only
respectful submission, my lord, at para D, capital D, page 8.
Yes.
Motor Vehicle Act 88 as well as OET Act has excluded tractor from the definition of motor vehicle. Tractor trolley is a pulled cart attached to a tractor, cannot come under the definition of motor vehicle, and further the tractor trolley has no independent function and the same moves or run along with the tractor, and therefore the tribunal
See, there can't be a trolley without a motor. I think the answer is there can't be a trolley without, with the motor. Unless the trolley has a motor, it can't become a motor vehicle.
Yes, my lord. Then the tribunal order is not maintained, my lord.
Let's see page 22. Page 22 or running page 22, internal page 3. Your Lordship. Before this forum, a single point attracting consideration whether learned assessing officer is justified in levying it on tractor trolley. Here we like to point out that at serial number 24, part 2 of the Schedule OET Act, motor vehicle, two-wheeler and three-wheeler. Tractor trolley is included in the term motor vehicle. The term motor vehicle has been defined in section 2H. Your Lordship, is defined to but 28 of section 2 of Motor Vehicle Act, and Motor Vehicle Act reads as follows. Motor vehicles means any machinery propelled vehicle adapted for use upon roads, whether the power of propulsion is transmitted thereto for an external or internal source, and includes chassis which a body has not been attracted and trailer, but does not include a vehicle running upon fixed rails or a vehicle special type adapted for use in factory or so on.
No, but what about 2H itself?
Your Lordship, so far as the judgment of Honorable Supreme Court.
No, 1 minute.
Your Lordship.
This doesn't notice this discussion.
Your Lordship.
That under 2H of the OET Act.
Your Lordship, 2H, the above 2H.
Without actually setting it out fully. See, the problem is the whole section was not set out.
Yes, my lord.
Your Lordship. That above that, the term motor vehicle has been defined under section 2H.
Yes.
Of motor vehicle to mean a motor vehicle as defined in clause 28 of section 2 of Motor Vehicle Act 1988.
No, that's a problem. It puts a full stop there.
Your Lordship.
But whereas the definition says excluding.
Your Lordship. The excluding that is tractor.
Correct.
Not trolley is there.
Hey, so once you exclude the tractor, that is not even noticed here. In this paragraph, the excluding portion of 2H is not noticed.
Your Lordship, that tractor has
That's
been
the most
excluded.
crucial thing, sir. See, it is the definition as it contained in the Motor Vehicles Act.
Your Lordship.
And takes away from the definition for some things. What it takes away from the definition is tractor, earth mover, excavator, bulldozer, and road roller.
Your Lordship.
That was completely omitted by the tribunal.
Your Lordship.
And there can't be a trolley separate from the tractor. The trolley has no motor.
Your Lordship, that's right. That's absolutely right. Only. Your Lordship, let it go to the tribunal.
No, why should it go back? All right. The present petition. This is 1 or 2 petitions.
Sub-item is different question of law. Same question or the similar question are already posted to 3rd January in another case.
Oh, I see. So in that STREV 34, you say list on 3rd January with that. All right. In STREV 28 now.
The question now is different from the line.
All right. In STREV 28, this revision petition by the SSC arises from an order 28th February 2017, passed by the Orissa Sales Tax Tribunal, allowing the state's public department appeal essay number 115 bracket ET oblique 2015-16 for the tax period 1st April 2007 to 31st March 2012 under section 9 capital C of the Orissa Entry Tax Act 1999 bracket OET Act. Stop. By the impugned order, the tribunal reversed the order dated 30th June 2015 passed by the Joint Commissioner of Sales Tax bracket JCST bracket Baleshwar Range. The first appeal filed by the SSC, thereby reducing the tax demand raised by the Sales Tax Officer bracket STO Baleshwar Circle on the SSC from rupees 938,490 to rupees 33 for the aforementioned period. Paragraph. The petitioner SSC is a dealer engaged in the business of manufacturing and selling single quotes tractor, trolleys, unquote, and other agricultural implements at Baleshwar. Paragraph. On the basis of a tax audit conducted in his premises, the STO initiated proceedings under Section 9C of the OET Act. Stop. Inter alia, it was found that the petitioner had not discharged his entry tax liability in purchase of certain scheduled goods from unregistered dealers outside the local area. Stop. The STO also subjected sale of single quotes tractor trolley, unquote, amounting to rupees 306,07898 by the petitioner to entry tax liability at 1%, treating single quotes tractor trolley, unquote, as a scheduled goods manufactured and sold by him. Stop. The demand, aforementioned demand, was accordingly raised apart from a penalty. Paragraph. While the SSE succeeded in his first appeal before the JCST, who agreed with him that single quotes trolley was not motor vehicle, thus attracting entry tax within the meaning of the OET Act, the tribunal reversed the order of the JCST and held in favor of the department. Paragraph. This court has heard the submissions of Mr. B.V. Mohanty, learned counsel for the petitioner, and Mr. Sunil Mishra, learned additional government advocate for the department. Paragraph. Section 2(H) of the OET Act defines the expression single quotes motor vehicle as under. Paragraph. The above definition refers to Section 2(28) of the Motor Vehicles Act 1988 (MV Act), which defines the expression single quotes motor vehicle to mean as follows. So reproduce the whole paragraph. It is evident from a comparison of both definitions that while Section 2(H) of the OET Act adopts the definition of motor vehicle as contained in Section 2(28) of the MV Act, it excludes from that definition single quotes any tractor, earth mover, excavator, bulldozer, or road roller, unquote. Interestingly, Section 2(28) of the MV Act includes a single quotes trailer, unquote, whereas Section 2(H) of the OET Act does not. Full stop.
Your Lordship may peruse last four
Section
lines.
2(28) of the MV Act envisages a single quotes trailer, unquote, that is attached to the vehicle. Full stop. There is no exclusion of single quotes tractor from the definition of motor vehicle under the MV Act. Full stop. However, there is such exclusion under Section 2(H) of the OET Act. Paragraph. A trawler that is attached to a tractor by itself cannot be classified as a single quotes motor vehicle, unquote. It is nobody's case that the trolley has any single quotes motor so as to attract such a definition. Paragraph. The court notes that the impugned order of the tribunal, while noticing Section 2(H) of the OET Act, stops short of noticing what was excluded from that definition.
Your Lordship, that is there, Your Lordship.
Yeah,
that
let's see that.
Your Lordship, just 4 lines above the second first paragraph.
Yes.
Thus,
yes,
as per the definition of motor vehicle specified in Section 2(H) of the OET Act,
Yes.
trolley is comprehended in the said definition.
It's not.
Since
That's what we're dealing with. It's
Yes,
not. It's
yes,
not. Yeah. Full stop. The conclusion of the tribunal that single quotes trolley is comprehended in the definition completely misses the point that the trolley cannot exist as a motor vehicle independent of the single quotes tractor, unquote, to which it is supposed to be attached. Full stop. Paragraph. In fact, the tribunal notes that under section 2(6) of the MV Act, single quotes trailer has been separately defined to mean any vehicle, single quotes, drawn or intended to be drawn by a motor vehicle, unquote. Full stop. This, in fact, underscores the intention, legislative intent, that only such single quotes trailer that is intended to be drawn by the motor vehicle will attract the definition of single quotes motor vehicle under section 2(28) of the MV Act. Full stop. As far as the OET Act is concerned, since the tractor itself is excluded from the definition of motor vehicle under section 2(h) of the OET Act, the question of bringing a single quotes trolley, unquote, as a standalone vehicle within the purview of that definition does not arise. Paragraph. For the aforementioned reason, this court sets aside the impugned order of the tribunal and restores the order of the first appellate authority. Stop. The revision petition is allowed in the above terms. No orders.
Lordship, I have a small prayer to make, man. In item 9, my lord, I have a small difficulty that the arguing counsel is from Delhi, my lord.
It will stay on board, sir. Let's see what happens.
May I pray for sometime in January?
Let it stay on board. We'll see what happens.
My lord. Item 11. My lord, in item 11, my lord, 3 questions of law has been framed on order dated 27th of July 2017, my lords. As page 44 of my revision petition. 1. Whether in the fact and circumstances case that the tribunal division bench or tribunal has right and law to order imposition of penalty under Rule 12(3)(g) of the CSTU rules on short payment admit tax of 1,51,500 is being assessed is just and proper, more so when separate mechanism has been provided under Rule 8 and 8A of the CSTU rules for levy of interest and penalty respectively. The question number 2 is, my lord, whether in the fact and circumstance case, the division bench would say tribunal is right in law to order for imposition penalty under 12(3)(g) of CST rules in respect of differential tax of 8,401 for non-submission of declaration from C. More so,
what's the total tax impact?
My lord, in respect of the first question is 1,51,000 tax involvement. In regard to the second issue, it is tax of 8,401 rupees, my lords. And my lord, in the last occasion, the last day, I had rightly guided me to go through the order of my lords on dated 8th of April 2022, your lordship. The circular of the commission has been relied upon, my lords. In the case of General Traders Berhampur, in the STR of 64 by 2017, my lords. Page 35, my lord.
Second question.
Page 35, my lord. 7.4, my lord. Relied upon circular dated 15th April of 20 of the Honorable Commissioner. In view of the efforts circular issued by the Commissioner of Commercial Taxes, instructing not to enforce penalty under Rule 12(3)(g) in the circumstances where there was a non-filing declaration forms in respect of bona fide transaction, particularly in absence of substantial provisions of such imposition under Section 9 of the CST Act, this court is of the considered opinion that the first appellate authority was justified in deleting the penalty age imposed by the assessing authority when finalizing deed assessment.
Here also it's CST.
My lord.
And you did not file the declaration forms, is it?
Yes, my lord.
This applies.
Your Lordship, that circular applies. Circular applies.
With regard to the first issue, Your Lordship.
So, Your Lordship, second issue may not be considered because that 8,000.
Second issue, nonsense declaration forms.
You have to submit.
Individually 8,000, but if you multiply the things both together, it will come to 1,59,000.
All right. What is this question? 3 is not necessary to be answered.
My lord.
All right. While admitting this revision petition on 20 July 2017, following questions were framed for consideration. Paragraph, as far as question number 1 is concerned, it is not in dispute that it stands answered in favor of the SEC and against the department by virtue of the circular dated 20th April 2015 of the Commission of Commercial Taxes, which referred to and applied in the judgment dated 8th December 2022 of this court in STREV 64 of 2017 bracket Messrs General Traders Berhampur versus State of Orissa bracket. Consequently, question number 1 is answered in favor of the SEC and against the department.
My lord, that is question number 2, my lord. Sorry.
Question 2, sorry. What about question 1?
With regard to withholding admit tax liability of 1,51,000, Your Lordships, 500. Withholding or admit tax of like 1,51,000 without resorting the provisions of Rule 8 and 8A for levy of interest and penalty. They have imposed penalty of Rule 12(3)G of the CSTO rules.
Right. CST.
Page 132, my lord. 132, my lord.
Yes.
The last one, the rescinded part, Your Lordships. G, without prejudice to any interest or penalty that may have been levied or imposed under any of the provisions of the Act, an amount equal to twice the amount of tax assessed under clause E or F shall be imposed by you a penalty in respect of the assessment computed under the said clauses.
Yes.
My submission is that this is a withholding of tax liability, my lords. So mechanism has been provided under Rule 8 and 8A, Your Lordships, for levy of interest and penalty, Your Lordships.
We are admitting interest. We are admitting interest.
My lord.
So it will simply have to go back for a fresh determination. Penalty for non-submission. 9 capital A. Missionary provision. No, which was just go back to redetermination. So it goes back to the assessment officer. Let's take that. All right. So cannot be an automatic thing, is it? What do you say?
Your Lordship, also the first appellate authority has set aside the matter for fresh assessment, fresh adjudication, Your Lordship.
So this has
On
to
the
go to the
levy of interest,
levy of
and
interest,
etc., Your Lordship. So, Your Lordship, on the entire issue, it may go to the assessing, sir.
All right. Anything will delete as far as 2 is concerned can be deleted.
Your Lordship.
You say as far as question 1 is concerned, in view of section 9, capital, 9 bracket 2 capital A and 2 capital B.
My lord.
Of the CST Act 1956, read with Rule 8 of the CST bracket O rules 1957. Or only the impugned order tribunal is set aside and the matter is remanded to the assessing officer for a fresh determination of the issue in accordance with law. So, in other words, the order of the GCST bracket appeal is restored to file. Paragraph. In view of the above answers to questions 1 and 2, there is no need to answer question 3. Paragraph. The revision petition is disposed of in the above terms.
Deep blue.
Item number 14. Item 14, sir.
14.
Sorry. Item number 14 of the same issue, my lord. Withholding government tax liability of 64,000, my lords. Same issue, my
Same
lord.
order. All right. In view of the order passed today by this court in STREV 36 of 2017, correct?
60,024, my lord.
That's it. No.
36. 36 of
2017. The questions framed in the present revision petition by the order dated 20 July 2017,
my lord,
are answered as under. Question number 2 is answered in favor of the SSC and against the department by virtue of the judgment dated 8th December 2022 of this court in STREV 64 of 2017 bracket Messrs General Traders Berhampur versus State of Odisha. Paragraph. As regards question number 1, the impugned order of the tribunal is set aside. The matter is remanded to the assessing authority for a fresh decision in accordance with law.
My lord, sorry to inform you that question number 2 may be ignored, my lord. That is the kindly
not answered in view of the answer to question number 1. All right.
Oblige, my lord.
All right.
Weekly list item 15.
Question, my lord, at page 7. My lord, this question is covered by case of automobiles. Similar provisions are there in 12.4a rules, Central CSTO rules, my lord, which said that where after a dealer is assessed under sub-rule 1, 2, 3 for any period, the assessing authority on the basis of any information in its possession is of the opinion that the whole or any part of the turnover of the dealer in respect of any period or periods has escaped assessment or has been under-assessed or has been assessed at a lower rate than the rate at which it is accessible, or that the dealer has been allowed wrongly any deduction from his turnover or exemption for the act, or has been wrongly allowed set off of input tax credit in excess of the amount admissible under clause small c of sub-rule 3 of rule 7 of the rules, he shall serve a notice in form IVA on the dealer.
Mr. Mohanty, the only difficulty you have is,
my lord,
the questions were framed, only question B was framed.
No, my lord, question number C, my lord.
No. But what was framed is only question B, because you did not have Keshav Automobiles at that stage.
28th November 2017.
We can reframe the question if you like, but what was framed by this court is only the penalty question.
Oh, my lord, my question that your lawsuit, may kindly reframe the question at.
I know, we'll have to reframe.
C, my lord.
Yeah, we'll reframe it. What do you say?
So he wants entire.
Let's see also. Also, so far as the penalty is concerned, also it is in their favor because May is there. So far, your lordship, please.
All right.
Sit again.
This revision petition by the SSC.
Yes,
Lordship, again frame that question.
Yeah, we have to reframe. Arises from an order dated 4th February 2017 of the Orissa Sales Tax Tribunal, bracket Tribunal, in essay number 90 bracket C of 2013-14 and essay number 143 bracket C of 2013-14 bracket States Appeal bracket arising out of an order of assessment as well as the first appellate order for the assessment period 1st April 2010 to 31st March 2012. Paragraph. Inter alia, the SSC had urged a question of law regarding the justifiability of the levy of tax and penalty under section 12 bracket 4 bracket small c of the central sales tax bracket Orissa bracket rules. When the order of assessment had made under section 12 bracket 4 bracket a of the CSTO rules on the basis of scrutiny returns without completion of assessment under section 12 bracket 1 bracket 2 or bracket 3 of the CST bracket O rules. However, framing the questions by the order dated 28th November 2017, this court framed only one question of law on the justifiability of the
I'm sorry.
penalty.
I'm sorry. In this provision, let's see, one thing has been clarified in this provision that shall be accepted as self-assessed without any further communication to the dealer. Let's see that without any communication. So for that reason, I may be permitted to go through the record. Let's see. Let's see, you can find out this at 12.1. Let's see, after Roman 1, 2, 3, 4, the said return shall be accepted as self-assessed without any further communication to the dealer filing such returns. And in that case, the date of submission of the forms of declaration along with the statement shall be reckoned as the date of self-assessment. Let's see, this is prior to 1/10/2015 because only 12.1a substituted what I think, let's see, maybe because till date, so far as the CST Act, let's see, has not passed any order. Let me.
You want to examine this?
Your Lordship.
My lord,
the wording.
After a dealer is assessed, I have not been assessed. The communication is separate part. My lord, my most respectful submission, I have not been assessed. I have not been assessed, and no assessment order has been passed in the order sheet or.
Sure, let him check the record.
My lord.
Let
him check the record, my lord.
So just take off all this. We'll stay on board then.
Also, I have not gone through this. Just now I have gone through this. So that,
right. The wording is different. You're right.
Your Lordship.
Right.
Item 16.
Both, I think 16 and 2 matters. None appears dismissed.
Item number 18.
Again, none appears dismissed.
My lord, on behalf of Mr. Odhiras Mandi, I pray for an adjournment because health is not fine today.
Which matter?
My lord, 18.
Has he filed a vakalatnama?
No, he has requested me to appear and pray.
Are you sure? What is the number that you have?
18, item 18.
No. STRV number.
My lord. 73/2017.
All right. Let's stay on board then. All right.
Item number 19.
My lord, in item number 19, my lord, by order dated 12th of March 2018, the question has been formulated, your lordships, whether in the fact and circumstance of the case, the single bench judicial member 2 Orissa Sales Tax Tribunal was right in law in holding that 150 HP fully automatic ATS control panel, motor starter control panel, and other panel are unspecified goods liable to tax at the rate of 13.5% and not falling on the entry serial number 29 of Part 2 of Schedule B of the OVAT Act. My lord.
Entry 29 Part 2 is what we have to see.
My lords. Page number, my lord, 160, my lord, of my lord's book.
Centrifugal monoblock, that one.
My lord, I am amongst other goods. I am also a trader for pump sets and accessories of pump sets, your lordships. The question of law, which the goods are under question are control panel, motor starter control panel, and other panel. So the question of law also indicates that there are motor panels, your lordship, which are used as the accessory to the motor panels for the purpose of starting, your lordships. That being the case, your lordship, although it is a electrical goods, as has been stated that it is not disputed that it is an accessory to the motor pumps, your lordships. I have been denied the benefit by holding that I am a trader of electrical goods, your lordships. It is operated by electric, your lordships, but no doubt this is accessory to the pump, my lords.
Accessory is something different. Component and spares.
You mean it's not separately purchased?
My lord?
No. If you went into the market,
yes, my lord,
and asked for a fully automotive ATS control panel,
my lord,
it won't be sold to you.
Yes, sir. It can be purchased by anyone, my lord.
No. So if it is identifiable as a separate product,
my lord,
how do you say it's an accessory to the centrifugal monoblock submersible pump?
Because my majority of trading, your lordship, on pump sets, your lordship. I'm a trader of pump sets.
No. Let's look at switchboards, for instance.
My lord.
Switches, plugs, switchboards. It's not; those will be electrical.
It is not. It is a combination of many parts, your lordships.
No. It is also an accessory to this centrifugal pump. You can't have a pump without a wire. You can't have a pump without a switch, a plug. All of that will be an accessory by your understanding.
Yes, as per my understanding, ATS control panel is given, your lordships, that it is operated by dual, either by electricity or by the diesels. When there is a failure of electricity, it will automatically switch up to the diesel modes. It is a it has been used in big big houses, your lordship, and it is used for the purpose of only pumps, accessory pumps, and not lordships.
No, it's not used for any other because motor starter control panel.
Yes,
it can go for any electrical gadget. It's not exclusive to some pump.
Motor means in local arts, motor starter means you used to say that is a pumps, your lordship. In Odia language, it pumps. We normally use the word to do pump. So pump is otherwise we call it a motor cell, lordship, as per the common language is concerned, your lordships.
Was any expert examined for this?
The goods have also purchased from whom also they also charge 4% tax and 5% tax, your lordships.
No.
So the root of the case also is on 4%, 5%, your lordships. And this is a very small issue, amount is concerned, not a big amount, your lordships.
So then leave it open.
let it be kept open.
The tax amount.
So without this, motor pump can run, Mr. Das.
My lord.
Without this, motor pump can function.
Yeah.
No, my lord. Motor can function, but it
can.
It cannot run, my lord.
No, there are many things.
My lord, kindly have to glance to page number 28, your lordship. The order of accession, page number 28, your lordship.
Page number 28.
Yes.
The details are there. Mini manual motor
starter, your lordship.
Delta panel.
Mini manual motor starters, control panels. So these are the DOL starter, direct starters, your lordships. So these are being used for the purpose of your lordships. Only a motor panel, accessories, your lordships.
Anyway, I think 52,000 is the effect, right?
Yes, my lords. It is a big amount for me, your lordships, because by the consequent interest will be multiplied, your lordship. Penalty, interest will be consequent. I will be in a difficult position, my lords.
Yes.
Your lordship has already interpreted.
So, but it is not an electrical goods, not an unspecified, your lordships.
No.
We're not satisfied about the accessories business.
Not without that, it cannot be functional. It can function.
Is there expert evidence for that? Some person who
then
deals
that
with-
matter be referred for exemption before by the assessing authority, my lords.
Is it affecting subsequent years' assessment?
No, my lord.
Ah.
Sorry, I don't have an idea, your lordship. I don't have no instruction.
To find out if it's affecting a large number of years, we can send it back. Otherwise, why?
I will ascertain, my lord.
Or I think we can stop here. Take a break.